All right, good morning, everybody, and welcome back to the Arizona State Board of Pharmacy meeting. Today is February 13th, 2025, and the time is 8:30. I will call the meeting back to order. Dr. Gandhi, if you can do roll call and see if there are any additional conflicts of interest.
Thank you, Madam Chair. Mr. Braswell.
Here, no conflicts.
Sir Thorwald.
Here,
Conflicts?
no conflict.
Thank you. Ms. Nair.
Here are no additional conflicts.
Ms. Davis.
President, I submitted my conflicts previously in writing.
Thank you. Ms. Walmsley.
Present, nothing additional.
Ms. Lahan.
Present, nothing additional.
Mr. Dang.
I'm here, no conflict.
Mr. Al-Nassif.
Here with no conflict.
And Mr. Anderson.
Here, and no additional conflicts.
All accounted for, Madam Chair.
Thank you, Dr. Gandhi. We will start with tab 26 today, which is cases recommended for the state's approval to deem. I will turn. Wait a minute, I'm not recused from that one.
Dr. Gandhi, could we, or Mr. Jacobson, thank you.
What do you need? Oops, hang on a second. My book is not cooperating. We'll start with 26A, which is Stephen Patrick Connolly, board case number 23-0039. Can we take those both together, Mark? 26A and 26B? Since they're consent. The consideration of both items, can we take them together? Okay. This is not navigating well. There it goes. Okay, this is the time for the board to consider consent agenda items 26A through 26B. Stephen Patrick Connolly, board case number 23-0039, and Nouf Khalid Alicante, board case number 24-0438. Does any respondent or board member wish to pull any case from the consent agenda for further consideration? Will the state's attorneys please introduce themselves?
Yes, good morning. Seth Hargraves, Assistant Attorney General on behalf of the state.
Are there any other parties present for these matters?
I know Mr. Connolly isn't, but I'm not sure about Ms. Al-Katani.
Staff, can I confirm?
She is not online, Madam Chair.
Okay. The state has filed a motion to deem and vacating the hearing in each of these matters. If these motions are granted, the board will have adopted the factual allegations set forth in the complaints as its findings of fact and alleged violations as its conclusions of laws. Is there a motion with regards to the state's motion to deem?
I'll move that the board grant the state's motion to deem and vacate the hearing.
Second,
I have a motion and a second. Any discussion? We'll now deliberate on the appropriate discipline to be imposed.
Then I'll move to adopt the state's recommended discipline as set forth in its motions to deem and vacate the scheduled hearings.
Do I have a second?
second,
Any discussion? Dr. Gandhi, roll call.
Mr. Braswell.
Aye.
Mr. Thorwald.
aye.
Ms. Nair.
Aye.
Ms. Davis.
Aye.
Ms. Walmsley.
Aye.
Ms. Lahan.
Aye.
Mr. Dang.
Aye.
Mr. Al-Nassif.
Aye.
Mr. Anderson.
Aye.
Ayes have it, Madam Chair.
Thank you. This concludes these proceedings. The decisions will be reduced to written orders and will be sent to each of the respondents. Let's move on to 27A, which is our informal settlement conference. for Happy Valley Pharmacy and Howard Pulver. Good morning. This is the time set for the consideration of the respondent's settlement proposal in case number 22-0565 involving Happy Valley Pharmacy and case number 24-0560 involving Howard Pulver. Are the parties present?
Jean Galvin, Assistant Attorney General on behalf of the state.
Reese Lance on behalf of respondents.
Thank you. The board will now hear presentations and arguments from the parties on the respondent's settlement proposal. As the party making the proposal, the respondent shall go first. The state will then have the opportunity to respond, and the respondent will be given time for a brief rebuttal. The order of our presentation will be the respondent's presentation and argument, the state's presentation and argument, and then the respondent's rebuttal. Go ahead, Mr. Lance.
Thank you, Madam President and members of the board for the opportunity to present this proposal to you today. Before getting started, I would like to extend my appreciation to Jean and the board staff for being so accommodating and getting both matters scheduled for this informal settlement conference. I know that they had to jump through some hoops to make it happen. I'm here today in hopes to resolve these matters with the board. I realize that this is our last shot at resolution before a hearing and my client's last chance to get his act in order. I trust that you have been provided the settlement offers that were previously submitted to board staff, but in any event, I will briefly summarize the proposed terms. As you know, there's currently 2 open cases, one case against Happy Valley Pharmacy and one case against Howard Pulver's pharmacist license. So as it relates to the pharmacy permit, we propose that the permit continue on a 12-month probation minimum and the retention of a pharmacy consultant. We have currently retained Michael Blair, who is past board president, to serve as the pharmacy consultant. There will be monthly inspections for 12 months. And after each inspection, there will be monthly reports that Mr. Blair will submit to the board. When the 12-month inspections are concluded, there will be a subsequent unannounced board inspection. Mr. Pulver and Happy Valley Pharmacy will be responsible for the costs associated with all of that. As it relates to Howard's pharmacist license, we propose 9 CEs in addition to what is required, and attendance at a 2-day pharmacy ownership workshop hosted by the National Community Pharmacists Association. In addition, issuance of a letter of concern. I believe that this is a fair proposal, and it is a very intensive. It will afford the board with consistent monitoring of the pharmacy's operations and compliance with applicable law. And it will ensure that the pharmacy develops proper systems and processes to ensure the compliant operations of the pharmacy. More importantly, this proposal ensures that Happy Valley stays in operation and continues to serve the patients of Quartzsite. I remind the board that the nearest pharmacy in Arizona is a 45-minute drive. So we believe that patient care is paramount here, and revocation would negatively impact the patients of Quartzsite. I do not believe that revocation is warranted here. There have been no allegations of patient harm. I do not think that revocation would be in the best interest of the public, as it would deny Quartzsite patients access to a local pharmacy. I respectfully request that the board accept this offer, and thank you for your consideration.
Thank you, Mr. Lance. Ms. Galvin?
Good morning, Madam Chairman and members of the board. The state takes no position with respect to the offer of settlement.
Thank you, Ms. Galvin.
Can I ask some questions about the statements that were made?
Yeah,
that
go
we
ahead.
have? One thing that's concerning to me is when you are addressing clutter, it just says they're still working on it. I think at this point, we would like to see that it's been addressed and completed instead of still working on it. Do you have any comments about that?
Yeah, so the clutter is definitely something that I understand is concerning to the board. And we have made improvements to address that. Michael has been out there before even today. He made a visit in December, and there have been improvements, but admittedly, so I can't speak to whether it would satisfy the board.
I mean, similar note, and there does talk about cleaning as well.
Right.
I'm not clear, is there an SOP? Are there certain people that are assigned to do certain duties? Like, I don't know that there's an actual plan in place except for that we're gonna be doing cleaning.
Right. And so he had a cleaning crew come in to clean. And part of our proposal is when Mr. Blair goes out there the first time, he will do a full complete assessment of the pharmacy. And from there, he can identify whether there needs to be additional steps taken as far as cleaning and clutter. And he will help develop those SOPs to make sure that moving forward, it's something that is addressed appropriately.
The problem is, Mr. Lance, is that this has already been done. You know, we've already sent consultants in. They provided a report of satisfaction. And I recall having the respondent PIC on video showing us the clutter in that pharmacy, and doing the same action again and just kicking it for another 12 months is unsettling a little bit for me. The actions that are proposed are essentially that, with, I guess, more periodic consultant reviews. I'll just leave it at that. Do you have any comments on the difference in this proposal versus what was done previously?
Sure. In the prior proposal, I understand that there was just one visit out to the pharmacy, and there was a report generated based on that visit. This is more intensive, and it requires monthly monitoring. So I think it will, the proposal will effectively ensure that things are being done to correct the board's concerns.
So why can't Mr. Pulver sustain recommendations independently of a consultant? What is his deficit in being able to sustain, compliant, cleanly sanitary pharmacies?
That's a good question. My perception is that there's certain things that he doesn't know. So he doesn't know what he doesn't know. And we've seen in the past that he's had trouble with cleanliness. So I think having a consultant there would kind of help push him in the right direction.
Would Mr. Blair's reports be submitted to the board staff on a monthly basis?
Correct.
I mean, the fact that having eyes on it by somebody else, independent of the pharmacy operation, does give me some degree of comfort. However, how long has Mr. Pulver been a pharmacist?
I believe over 20 years, since 2006, I believe.
The fact that you say that he doesn't know how to comply also concerns me, and it makes me question whether or not he's able to practice in an unsupervised way. I mean, he's the sole pharmacist, he's the owner, he's the pick. There's not anybody else to consult with. I mean, I understand that we're looking at hiring a consultant. Like I said, that gives me some degree of confidence, but it's not like he's a new graduate and this is the first, like that he's a new pharmacy owner. These are things that I would have expected him to already know. So that gives me some concerns about him personally.
If I may, Madam President, even though he has been a pharmacist for a long time, I think he's still relatively new when it comes to pharmacy ownership.
Thank you. Mr. Hyper, Mr. Patel, I think one of you or both of you wanted to make a comment.
I just wanted to state that this is Steve Hyber, compliance officer with the board. Officer Patel had some latest intel he received from the pharmacist in charge owner of this permit.
Thank you.
So this is in addition to what Mr. Lance explained that Michael Blair was there in December.
Correct.
So we went there to address a complaint in the end of January 30th. And the pharmacy looked exactly the same as I remember it more than a year ago. Nothing had changed, but since then, he sent us several photos of how he's changed the pharmacy. He's reduced the clutter. He's put signs of where the food belongs, where the break room is, and where the drugs are. So I've seen a lot of improvement, but that just happened the last week or so. And that's all I wanted to add.
Thank you, Mr. Patel.
I have a comment as well. Given the person's experience, even as a pharmacist, you need to be clean. You need to have certain things you have to do to be to keep the whole area clean, not just as an owner. And given that he's had all this time to do it, it seems like moving forward, the only way this person is going to be able to continue doing the right thing is to have somebody monitoring them 24/7 to be able to do that. And that gives me great pause in other areas to whether he is even capable of doing that and how quickly that would drop off, not just in the cleanliness of the facility itself, but in handling products.
I believe the hope of Mr. Blair being there for a year and doing the monthly inspections is to develop systems to ensure that he continues to comply. And that's why we crafted the proposal in the way that we did.
Well, and as far as the consultant and the follow-up, I feel significantly more comfortable with that part of how things are being brought to us with the monthly follow-ups. I feel like prior when they had the consultant in there, that a lot of the things that needed to be addressed didn't have much follow-up at all. And then he was told, this is what you can do, or told that this is okay. I mean, I remember reading that the consultant had said, oh yeah, everything's fine. And then we look at stuff and everything was clearly not fine. So I do believe that putting systems in place would be really important, that they could continue to follow through. Himself being solely responsible for continuing those after that time period. I don't know how I feel about that.
Maybe a potential offer on our end would be to not allow him to be the pick.
Another thought, if we added something in that if he did not maintain this at ongoing, that there would be some way we could move to revoke his license, so that there is something continually hanging over his head to ensure that if he has a pop inspection that and he's not meeting the requirements, bad things can happen as far as his license. Something like that, maybe not exactly what I've said, but something like that that gives him more motivation in the future than just learning again what he should already know about keeping the place clean.
I think that's implied with all the action we've already taken.
I like where you're tracking, Mr. Thorwald, because, you know, for Mr. Patel to come up here saying that he went down there for an unannounced complaint visit and saw the same thing that we've been seeing for over a year. And it wasn't until he had a visit from a compliance officer did he actually make any sort of meaningful change and presented some photographic evidence that he did have some meaningful change. But it took yet another compliance officer visit to get him to a better place. I like where you're tracking. I don't know how to necessarily formalize that sort of plan or in conjunction with what's been proposed, but.
Well, from a legal perspective, is there some way that we could do that so that we wouldn't have to go back through all this process again, and we could just jump forward and say to a hearing or to some other mechanism to be able to move this forward more quickly at the other end, if that would be the case from an inspection that was not properly taken care of?
Just to echo Mr. Anderson's statement, based on my understanding, Mr. Blair was there in December of last year, correct?
That is correct.
And then our compliance officer went back to the pharmacy not too long ago on January 30th, which was a couple weeks ago. So theoretically speaking, the owner had almost 2 months to work on all the things that were pointed out by Mr. Blair, but he didn't. The pharmacy, according to Mr. Patel, the pharmacy looked exactly the same as years ago. So just based on that statement, that tells me that Mr. Polvo did not take anything that's provided to him by the consultant or by the board seriously. So that's my biggest concern.
Mr. Hyber, can you remind me of the timeline on this whole case? So this started as a inspection, repeat violations from an inspection?
Yeah,
Is that
'cause
correct?
I
Like
looked over.
when did all the non-compliance start?
Yeah, that's a good point. I looked over it yesterday just in preparation. If we want to go back to how this all began, there was an inspection performed back in April of 2021, 7 violations. This was the routine inspection, and it's really what generated the initial complaints and the opening of the complaint case, the one that we're talking about, 22-0565. And then a board ordered inspection went back in. That was done in June of 22. And now we went from 7 to 9 violations. And back to the board it went. And then the meeting that we held requesting another board ordered inspection. That was performed after they met with the outside consultant. And we performed an inspection. That was the one I was involved with, April of 2024. And we came back to the board in October and presented those findings. And then I think the result of that was basically moved to hearing.
And how many violations were found on the 2024 inspection?
That one we issued
9, I believe.
9. And then, of course, there was one more added to the complaint by me after we got a response concerning the lack of backing up the computer system. Because one of the reasons for the controlled substance loss that we found was allegedly because the computer system, had a failure and there was no history of dispensing. Therefore, it looked as if they may be short because of that and not because of some other, event. So 10 violations at the end of the day for the board ordered inspection.
So this goes back, just to summarize, to 2021.
Mm-hmm.
It goes back quite a ways. Yeah, the initial one didn't involve any board action at that point. It was just simply a routine inspection with 7 violations. And then it got before the board.
because of the repeat violations,
Right.
and then we've just kind of snowballed from there.
Right. We've had 2 board ordered inspections, rather unique. I can't recollect too many, you know.
And we're increasing the number of
Mhm.
violations, not decreasing the number of violations. So we've really not seen any measurable change
Mhm.
in a period of 4 years, roughly.
Correct. And you know, the lack of records concerns me. I just want to put a fine point on it that if you don't have records, then you really are blind to whether you really have other events happening that are much more serious. So I view missing records is almost as bad as a confirmed diversion.
Mhm.
I mean, this is a really challenging one for me. The last thing I want to do is take away pharmacy access for Arizonans, but I also have concerns that this is not a safe environment today for people to fill prescriptions. So, I mean, I feel better knowing that there would be somebody there on a monthly basis, but I don't know that I can feel good about Mr. Pulver's ability to practice without having something else that gives me some level of comfortability. I mean, it's great that he's willing to attend a conference. It's great that he's willing to do CE, but how do we know that he's competent? I'm kind of in my head thinking, do we want to look at having him take the NAPLEX again? Do we want to look at having him take the MPJE again? I know those are pretty high bars, but that's how we can determine whether or not he's competent or not. That's what we would establish for a new graduate coming into practice. I mean, if he can get his operations cleaned up and he can prove to us that he's safe to practice, I mean, I want him to practice. I want him to serve the citizens of Arizona. The last thing I want to do is stop access in a rural
Mhm.
community.
I agree.
Well, and is he going to be dedicated to making those changes? Because I feel like there needs to be an ongoing accountability. I don't know that he should be the pick of this facility.
Mhm.
He hasn't demonstrated that he can do
I
those.
I don't know that I think he's taken any of this seriously to
No.
this point. I mean, like I said, I have a really hard time with this one because I don't want to take away access for Arizonans, but I also don't want somebody to get harmed because they're in a rural area. That's not appropriate either. Just because somebody's in a rural area doesn't mean they should receive substandard care.
True.
Exactly. And I think, you know, there's a standard of practice, you know, by our rules for the practice in the state of Arizona, and it shouldn't be different just because it's in Quartzsite than
Yeah.
it is in Phoenix. And there's standards of care, you know, that are defined by our rules. And I think there may have been some leniency and due to the fact that it's in Quartzsite and we don't want to take away access, but we're at a point now that we've got to protect public safety.
Correct.
And we've continued to kick the ball down the road for 4 years. I mean, and it's not getting better.
Madam Chair, just a question for Mr. Lance. Just out of curiosity, how long has he owned this pharmacy?
I believe since 21.
Oh, since 21,
I
since
believe-
when he was open.
Right.
See,
I go back to my original question. Is there a way legally to hold more, hold action in reserve? In other words, not have to go through the entire process that we normally do, going straight to hearing or something like that to, if we would move forward in some way?
I think he's alluding to a state revocation
Yeah,
process.
Madam President, members of the board, I'm not sure this board's practices, but clearly in a consent agreement, if the parties agree to it, you can impose a state revocation, meaning that the license is revoked or the permit is revoked. That revocation would then be stayed subject to the full compliance of whatever terms of probation you think are appropriate for them to fulfill.
Mhm.
To me, I think something like that is what we should do.
Right. Just a thought, Madam Chair. For the permit, I think we should consider revoking the permit for the pharmacist, for his pharmacist license. I agree with you, but we should consider having him retake the NAPLEX and the MPJE.
I mean, to me, it where my head is I need to understand that he's competent to operate without personal supervision. So I would be okay with keeping the pharmacy permit open and it, like knowing that we have the eyes on it. But I don't know, would Mr. Pulver be willing to enter into a interim consent to retake the NAPLEX and the MPJE?
I believe so. I would certainly encourage him to do so.
Would he be willing to hire another PIC and not be the only one?
So I think the issue with that is historically he's had trouble finding help. You know, it's about a 3.5 hour drive from Phoenix. He is the sole pharmacist at the pharmacy. I think he would be willing to, but I just don't know how practical it is.
But Mr. Lance, there's staffing agencies out there. If he's willing to pay the pharmacist, pay for the room and board and everything, I'm sure he will get someone to work as a pick there.
I don't know about that.
I don't know about that either. But again, the reason I feel the way I do about it, whether he takes those tests or not, doesn't necessarily mean that it resolves the problem. There are people who have experience and who do have understanding who, how do I put it, are not particularly clean in what they do or how they live. And if this person is that way, so what if they're knowledgeable and they understand things? That doesn't mean they're going to follow through. To me, they need something that is a hammer over their head that says, if I don't do it, I'm going to lose it.
Have we ever done any more board ordered inspections on a routine or a unannounced quarterly basis? Have we ever done anything like that? Intensified the inspections?
Even if we do that, that doesn't mean everything is fine in between. Rush around the day before and make it look good, and then I don't think that's an answer.
But unannounced, you won't be able to rush around the day before either. So that would help us with some knowledge that
It also wouldn't help with policies, procedures, things that would be needed to be in place. It would just help with possibly the clutter, but
This would be in addition to the consultant monthly inspections that have already been offered.
I also think about what the impact is to the board staff. So, you know, to the travel, I mean, obviously we could charge Mr. Pulver for it, but that means that our compliance officers also aren't looking after the other pharmacies in the state. I mean, this is going to take at a minimum a day each time that we send them out there because there aren't other pharmacies to inspect in that area. So they drive 3.5 hours to complete an inspection and then drive 3.5 hours back.
The other side of that too is if it isn't approved, we're going to be right back where we are right now
Right.
and have to do the same thing all over again. And he's already had 4 years. So to me, if I was on the other end, I would be counting, I'm in the same position. I'll just get by keep going. I can move these people forward more and more and more, and there'll be no action. That's why I keep leaning back strongly toward having that hammer over his head that you're going to lose it if you don't keep this place up. And here it is. It only takes one more shot and it's gone. That's what I personally think it will take.
would we need to go to hearing to do a state revocation?
You can make that, Madam President, members of the board, you can make that a term of the consent agreement.
So I believe, I mean, I don't think he can be a pick, from my opinion. I mean, we don't need to wait to decide about he able to manage pharmacy or not. I mean, obviously, within 4 years, he failed to prove himself as the pharmacist in charge. So I'm not sure about retake NAPLEX, but for sure, the law exam, he should be on probation with not practicing as a preceptor or a PIC. And for him to lift the probation, he has to pass the last exam, so he can't go to be a PIC in future.
But I'm going to play devil's advocate.
Yeah,
Can't find a pick. What does that mean?
but are we willing to put the public in danger of just, I mean, I believe that's the issue he should handle, because there is maybe staffing company, maybe he can reach out around the area to see like a pharmacist. How many retail pharmacists, they're just like looking for a pick. It is, I mean, it is not an easy job, but this is his responsibility to find someone.
That's true. I have to say, it's not a definitive that he won't be able to find a pick. I'm sure he will be able to find somebody if he paid them, with the right amount. There's a possibility.
If there is any rules that a pick has to be full-time, there's no rules with the state board, right? I mean, pick can be, there's no definition. So he can find like even someone willing to work a few hours a week to be a pick for his pharmacy, but he will take the responsibility for this.
Yep.
Maybe somebody travel from Phoenix to there and like be a pick. I mean, I believe he is responsible to fix the issue. Our responsibility is to keep people safe. So I agree with you. We should not close the pharmacy. We need Arizona to have access to their medications, and I would like to keep it open, but I don't think he is capable at this time to be a pick. Maybe in the future. I would disagree with retake the NAPLEX. I agree with the law 100%. That's conditional to remove the probation in the future. He has to pass a law test.
Well, to my
Well, we can-
understanding,
yeah.
NAPLEX questions also covers some of the federal laws, pharmacy laws too. So that's
Okay.
why it's good for
Yeah.
him to take
Okay.
retake the NAPLEX.
No, NAPLEX is only clinical.
Only clinical.
There's
NPJE is federal and state law.
Yeah. So that's why the question was about his knowledge more than his management skills and following the rules.
I've got to say that if I was a pick, I would not want to drive the 9 hours both ways to get out there and back. And I wouldn't particularly want to live out in that area myself, but that's me. What the point I'm trying to get by saying that is, it seems like I still think that hammer approach is much better. We can certainly ask for him to try to find a pick, but if he doesn't, we're still back in the exact same boat we are right now.
I don't think he cannot find a pick, because you cannot have a pharmacy run without a pick. They only allow it for a certain time, to my knowledge. And
No, we don't
staff can
allow a
correct me.
pharmacy to operate without a pick.
I mean, in transition, like we don't. Okay, so that's good to know. So that's his responsibility. I mean, he has to find a pick. And if he cannot find a pick, he would give like 14 days to close his pharmacy.
I mean, that will ultimately end up in closure, right? At that point.
I still feel that when there's a will, there's a way. If he advertise or reach out to staffing agency, pick the right salary, there is a possibility.
I mean,
There are
there's
pharmacists
a
out there.
possibility for anything, but there's also a possibility that it doesn't happen. I mean, there are significant staffing shortages across the state, and the reimbursement that pharmacies get in communities also is a factor to this. I mean, he can't pay an infinite amount of money and expect to stay in business either. I mean,
But
you
then
can't pay somebody $200 an hour and expect that they're going to drive there if you don't make $200 to keep the pharmacy open. I mean, that doesn't make sense.
They're only filling like 70 prescriptions a day.
Yeah.
The economics
They
wouldn't work.
economics don't support 2 pharmacists.
But we've got to go back to our mission of serving the public safety.
That's true. But on the contrary, if he can't find a pick and if he cannot work as a pick, then he
And the
would have to
pharmacy's
close
gonna
down the
close.
pharmacy.
Right.
I'd like to make a motion based on what I was trying to say earlier, and I'm not quite sure how that wording would come out. So if you could help me out with what you said earlier. And
Sure.
about how we could
Right.
in an agreement say that his pharmacy will be closed but we will put it on hold that as long as these things are maintained, that won't happen.
Yeah, so my understanding, Madam President, members of the board, what you're looking to do is perhaps offer the permittee a consent agreement, and part of the terms of the disciplinary order would be to revoke the permit, however, stay the revocation of the permit subject to compliance with whatever terms and conditions you deem appropriate. Should there be any violations of those terms of probation, the revocation, the stay would be automatically lifted and the permit revoked.
That would be my motion, with an additional that there is a consultant that comes out monthly to help him get this thing straightened around. It gives him some instructions to move forward.
So keeping the other terms that they had presented for the most part
Yes.
and adding that.
So basically extending the terms of probation for an additional year, but adding the stay revocation component?
2 years.
2 years, I'm sorry, thank you.
So the consulting agreement that was proposed was only 12 months. Would we want the consulting agreement to be 24 months?
Yes.
Would the consultant reports come to staff regularly? Do we want to add a stipulation that if there's a unsatisfactory report, it automatically goes to state revocation?
I would like I think that either it should be a compliance officer goes and investigates, or it should come back to the board.
My concern with the 24 months of the consultant would be that then we still do not see that he can maintain that on his own. So if you do the 12 months of the consultant, then the next 12 without, we can see that this pharmacy is going to be able to maintain on its own.
That's actually a really good point. And maybe quarterly inspections or twice a year inspections unannounced by the inspectors.
I'll amend my motion to be 1 year with quarterly inspections.
So the first year would be monthly, the second year would be quarterly, is that?
No, monthly from the consultant is what I'm hearing for the first year, and then no consultant the second year, but quarterly board inspections.
Thank you.
Would we want quarterly board inspections during the consultant period as well? I mean, we've had some concerns with the quality of consultant reports. Would we want to?
I don't think it's necessary.
Okay.
They're gonna, Michael Blair will be sending them to the board. So we would see his reporting.
And we should probably have another unannounced inspection in the next year, I would expect, right? The chances are we will have another just routine inspection.
And that was part of their terms in here too, requested.
To be sure, the terms had included a unannounced board inspection after the 12-month period. But obviously we're happy to work with that.
There were no competency requirements in your motion,
I
correct?
think that was for the permit holder.
For the permit holder.
Oh, thank you.
Dr. Condi, were you going to add something else?
No, that's what I was just clearing up.
Okay. Do we want to handle those two things separately?
I think it makes sense to.
Okay. Any further discussion, or do I have a
I
second?
just feel more comfortable if we have quarterly board inspection for the 2 years period. Evidence has shown that the owner didn't even care about Mr. Blair's advice. Well, he went there in December.
Or
And
Mr. Van Hassel's advice.
Well, Mr. Van Hassel said everything was okay.
But this has a bigger hammer that makes him want to do those things and wants to pay attention, because if he doesn't, he loses everything.
And recognize if we do those, we have a state revocation and you do those every quarterly. We may not, I know that they need to get it taken care of right away, but there may be some things that take a little bit time.
I'm
Maybe for
also
the-
sensitive to the board staff's time. I mean, we're talking about an extensive amount of time.
Maybe for the first year, we'll have the board compliance officer go there twice a year, and then the second year, every quarter. Since the second year, we're not requiring the consultant's presence.
I think that brings up a question as to when on our initial visit, let's say it's 6 months from the start of this thing, that we find the facility still not up to par. When does the stay revocation kick in?
At that point.
At that point.
Although that's something that we'll need to talk about, because I thought I heard Madam President mention that she wanted it to come back to the board for review. And so we just need to be clear what that is so that we can put that into the consent agreement.
Yeah.
Is it triggered by a monitor's report? Is it triggered by our inspector's report? Or is that information come back to you and you'll consider it either at a special meeting or?
My personal opinion is I want to see it. I don't think that it should be one person's decision to revoke a permit. I feel strongly.
Yeah,
about
that would be a difficult
I think
position
that's
for
appropriate.
us, because they may not be 100% by our initial visit, but there's progress. And
I think that's
So-
appropriate to come back to the board.
As a point of order, they are proposing this to us. Now we're making a decision. Is it that
it's a
we?
counter proposal.
A counter proposal.
Yes.
So we have to wait to see that they accept, or you're prepared either way to be able to accept today?
I'm prepared to be able to accept today. And obviously we'll have to iron out the consent agreement or the interim consent agreement.
Any further, yes, I'm sorry.
Sorry. I know there's talks of the progress of cleaning this. Is it really an interim consent agreement at that point? It's a consent agreement, I would think.
Yes, this would be your final order in this
Correct.
matter to resolve this
Okay.
complaint.
So, and to clarify, the pharmacy is currently on probation. So they are on a consent agreement for probation currently.
And procedurally, I believe they're up for renewal as well. So I think they would have to be renewed should we.
Yeah, and that's something, Madam President, members of the board, if it's okay, we can, I believe that's item 22C on the agenda, and we can maybe take that up after this motion.
Madam Chairman, if I may, is it my understanding that if the consent agreement is not signed, the matter would be moved to formal hearing? You would give them a 14 business days to sign, or 14 straight days to sign or go to hearing?
Mm-hmm.
Yeah, I think so. I'm seeing yes.
That seems reasonable. Is it possible to restate the motion though, so that we all are on the same?
Yeah, we
page?
also didn't have a second, I don't think either.
Thank you.
Do you want
I'll
to
second.
do you want to restate the motion, Frank, or?
Or staff, or
Let's.
I mean, Mr. Thorwald, I can take a stab at it if.
Okay,
if you'd
thank you,
like.
Cam.
So we have a 2-year probation. For the first year, we're gonna have a consultant visit monthly, board staff to visit twice a year for the first year. And those are unannounced, paid for by, all these board inspections are paid for by the permit holder. Second year, no consultant, but the board would visit quarterly. And this is the entire probationary period of 2 years. If not signed within 14 days, go to hearing.
There was another key portion of that for revocation.
Yeah,
And
it was,
State
put-
revocation.
yeah,
but do that right now, but then suspend the revocation as long as the work is done, and then at that end of that point, if it's not, it comes back to the board.
correct.
Yes. Thank you.
Okay, so that's your motion. Do I have a second?
Second.
Just for clarity, so what's going to be the trigger to bring it back to the board? One of the board inspectors violations that's noted? What's going to be
The board inspection violation.
I would,
Well, I would think, I'm sorry.
I would suggest, or a violation noted by the consultant.
Yeah.
Okay, and or a violation by the consultant.
I throw in another thought. That violation would be at the 3rd month. I'm sure the initial month, they're not gonna be able to get a lot of resolution, but
I think that makes sense. Let's give them a little bit of time.
At least 3 months to maybe get some traction.
That makes
or
perfect
movement
sense.
on progress.
So any hints in the reports or the inspection, 90 days after the consent agreement becomes effective?
Yep.
Everybody good? We have a motion, second by Ms. Lehan. Anything else? Okay. Dr. Gandhi.
Mr. Braswell,
Aye.
Mr. Thorwald,
Aye.
Ms. Snare,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Lehan,
Aye.
Mr. Dang,
Aye.
Mr. Al Nassif.
Aye.
Mr. Anderson.
Aye.
Ayes have it, Madam Chair.
Okay, let's do the renewal and then we'll go back to Mr. Pulver.
Yeah, and so this
Or
was
the
just
hearing.
scheduled for the informal settlement conference. We don't need to move to continue the hearing or anything.
I would think that, we could do that in one motion if we reach the same consensus with, Mr. Pulver. Or you could handle it separately and vacate, the referral to formal hearing, assuming this is signed.
Okay. So let's do the renewal, and then we'll go to Mr. Pulver's.
Okay, and then we can vacate the hearing on Happy Valley.
I think, subject to a signed consent agreement.
Okay. Okay, so item 12. Oops.
L.
I'm sorry, is Mr. Pulver's license, yes?
No, that's Mr. Pulver's complaint that Mr. Lands requested to have rolled into this informal settlement conference.
So what is the renewal?
22C.
22C is the renewal. Okay. Sorry. 22C is the renewal license for Happy Valley. So I'm thinking here we would make a motion to renew the license pending the signed consent.
Mm-hmm.
Second.
Under probation.
Yeah, that's the term of the consent. Yeah, any further discussion? All those in favor?
Aye.
Yes.
Let's. Any opposed? Hearing none, motion carries. Let's direct me, do we want to go back to Mr. Pulver's complaint? And then do the,
Yeah, I apologize. Mr. Pulver's complaint is 12I. And as I understand, Mr. Lands had requested this be addressed in informal settlement conference.
correct. So we've already kind of discussed Mr. Pulver's situation. Thoughts on how we want to address His proposal. So the proposal that you offered, Mr. Lance, was the CE and the continuing in the conference, the owners conference.
Yes, and an issue. Say that one more time.
You said a letter of concern.
Yes.
I liked Mr. Nassif's thought process for Mr. Pulver.
Remind me what that was. That was like
Can't be a pick.
2 days ago.
I forgot. I'm so sorry. It is. So I proposed on probation cannot be a pick during his probation, and in order for him to lift this probation, he has to pass the law exam. This is my motion.
I second that.
So thank you, members of the board. With respect to your motion, it's to offer Mr. Pulver a consent agreement.
Yes.
And the conditions would be that while he's on probation, he cannot serve as a PIC, and that he would need to successfully retake the law exam. Can you put a time frame though for that?
I would say so. My motion. If he doesn't pass the law exam, he cannot be a PIC. I don't know that work. And for him, in order to lift his probation, he has to pass the law.
It's almost like a permanent practice restriction that could be lifted pending receipt that he successfully passed the law exam.
If that's doable, that's what I was thinking.
If he doesn't pass the law exam, should he be accessing at all?
Exactly.
So you disagree with me now? Just kidding.
I never said I agreed with you in the beginning.
The other side, the other side of that is if he can't practice from this point on, and we do that, that's effectively shutting down the pharmacy.
That's my concern. I mean, I don't know that I can get behind that he can't be a PIC. I have concerns about it, but I also understand the realities of finding a PIC in that area of the state.
I agree with that too. That's concern. We're putting a huge barrier in there. When maybe we could work on trying to take care of our concerns with him and his competency in a different way instead of putting that barrier there where the pharmacy may close because of it.
I think he should be required to take the tests and to go through the courses.
So what if he failed the MPJE?
That's obvious.
What would be the consequence?
Then he needs to come back before us and we can decide.
Could we consider the state revocation process that we did for the permit?
Yeah.
I also don't want to get in the way, but because my understanding is that the posture of this is, it's still kind of in the investigative phase. We're doing an accommodation to treat it as an informal settlement, but if you felt like you needed more information regarding Mr. Pulver's competencies, you could issue an interim order, requiring him to take whatever kind of evaluations or tests you think are appropriate. That would come back to you, and then you could decide what your final action should be.
I like that.
I like that as well.
I think it would be nice to keep this pharmacy ownership workshop within that. I mean, I know that's 6 months or like 4 months away, but I think that's going to be one of the key things to helping to keep that this pharmacy will run smoother.
I agree with that.
So we have a motion and second. I rescind my motion. Right? Do I need to rescind my motion?
That's up to you.
Yeah, I rescind my motion.
Rescind my second.
One of the things that you may want to do as you're considering this, though, is hear from the parties and get their thoughts on it as well. Because again, this is kind of a hybrid situation with Mr. Pulver. And I know that there were discussions, and I certainly don't want to, interfere with whatever's been talked about prior to this moment.
Mr. Lance, Ms. Galvin.
I don't have anything to add.
Okay.
I like the suggestion of an interim consent order. I think that gives us the ability to have him take the MPJE and then based on his passage, come back to the board and decide what they want to do with his individual license. I don't think that at this point it would make sense to have him be on probation and effectively stop him from being the pick, because that will close the pharmacy.
If he can't pass the MPJE though, should he practice as a pharmacist?
Right.
That
Well,
that would
that's-
be, that would
which will
come back
close
to
the
you
pharmacy
for
too.
your decision.
But I think that gives us a very clear picture. And I mean, at that point, I mean, if we give him, say, 6 months to take the nap, give him 6 months to take the MPJE, that would potentially give him 1 or 2 attempts even maybe, and then we have the inspections, and we'll have at least 1 board inspection at that point. We'll have multiple consultant reports at that point too, and we could determine where he's at and where the pharmacy's at that point.
Is that a motion?
But if he can't pass the MPJE, are we continuing to kick it down the road? If he can't pass the MPJE in 6 months, what are we going to do in 6 months?
It comes back before the
Comes
board
back to
for
us.
for further discussion.
And at that point, we'll have additional information on how the pharmacy is looking as well.
I agree with you, keeping the 2-day ownership course would be helpful.
I don't see a date on that for 2025, but 2024 was in October.
I believe the 2025 was in May.
Yeah, it says May 2nd and 3rd.
Yes.
Okay, that's
Okay, does somebody want to take a stab at a motion?
Make a motion for an interim consent for Mr. Pulver to take the MPJE and within 6 months, and to attend the 2-day ownership conference in May.
Second.
I have a motion and a second. Any further discussion?
Do I need to say if not signed, proceed to hearing? Okay, I'll add that.
Yeah, you would, yeah, whatever the appropriate next steps would be.
Are we interested in including that 9 hours of CE that they?
We've
put
already
in there?
given disciplinary CE in my
Okay.
recollection. He'll have to study. That's probably better than CE offerings in many cases.
And if not taken in 6 months or passed in 6 months, bring it back before the board.
Correct.
Okay, perfect.
If I may, Madam President, Ms. Whitehead, the board in a final order can order additional CE. This is just for the interim.
Is it appropriate for that ownership class? In an interim order?
In my opinion, it is because of the timing.
Okay. Okay, any further discussion? Are we in order, Mr. Harris?
I think so.
Okay.
Yes, thank you.
Dr. Gandhi, go ahead.
Mr. Braswell,
Aye.
Mr. Thorwald,
Aye.
Ms. Nair,
Aye.
Ms. Davis,
I.
Ms. Walmsley,
Aye.
Ms. Lehan,
Aye.
Mr. Dang,
Aye.
Mr. Al Nassif.
Aye.
Mr. Anderson.
Aye.
Ayes have it, Madam Chair.
Thank you. So then I think that takes us to 28A. Yes. Jennifer?
It does. And procedurally, Mr. Harris, would we want to vacate 12I, the complaint that was moved for Mr. Pulver into the informal settlement conference, just so that's accounted for?
So can you share with me again the posture of that?
Sure. So at a previous board meeting, the board asked to add Mr. Pulver to this complaint for a response. He was added, and that is in 12I. Mr. Lands requested that the matter be considered instead at informal settlement conference, which we just had. Would we procedurally vacate agenda item 12I since it's been addressed in informal settlement?
If I may, I believe a separate complaint was opened.
This is in 240560 or 60, is that correct?
Mr. Lands, I think what you're referring to is not on the agenda for today.
I might be mistaken, but I thought that 240560 was the complaint that was opened against Howard Pulver.
The complaint in 12I is 24-0560.
I think that's a complaint.
That's also a complaint that's listed on 27A.
That's right.
Correct.
So since we've addressed the complaint in informal settlement, can we vacate the complaint in 12I? This is the
I
same
don't-
matter.
Yeah, I don't think that we want to vacate it. It's just been addressed.
It's been-
And we can have the minutes reflect under the prior agenda item that it was addressed under
And
the
that
informal
interim-
settlement.
Yep. and
Or
you
the
would-
interim consent agreement.
Yes.
Yep. You would
It would be
itemize it.
consolidated, essentially. They're on the same track, generally.
Thank you. So then, Ms. Walmsley, that's correct. The 28A is the last piece of this.
So it would be appropriate to take a motion to vacate the hearing
To vacate the hearing?
for 28A, which is Happy Valley, since we addressed it through the informal settlement, or do we need to address it
Well,
at all?
I would think the motion would be to continue the hearing subject to the signing of the consent agreement. And if not signed, I think it goes back to the formal hearing stage. That's my understanding of the posture of
Correct.
that case.
Correct.
Mr. Harris, if I may add also, I think Mr. Lance said he had the authority to accept the terms today.
Yes.
Are the terms that were itemized for Happy Valley and Mr. Pulver acceptable to you?
Yes. Thank you.
Okay.
Then perhaps what you could do, Madam President, members of the board, entertain a motion to vacate the hearing subject to him successfully signing that consent agreement for Happy.
So moved. Do I have a second? I have a motion and a second. Any discussion? We can do roll, right? All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Thank you, Mr. Lance.
Thank you, board. I appreciate it.
Thank
We
you.
have 3 more hearings. I have a request for a bio break. Do we expect anybody to appear for these, Ms. Galvin? Yes? Okay, let's take a break till 9:45. 8 minutes.
So you're leaving now?
Yeah.
And I'm not the last one.
She's gonna show it.
Probably not. Welcome, everybody. Let's go to item 12B. This is the date, time, and place where the matter involving Stuart McNeal, board case number 24-0322, is scheduled to be heard by the Arizona State Board of Pharmacy. This is the formal administrative hearing to determine whether there have been violations of the board statutes and rules and whether disciplinary action is warranted. Board members present today include Lori Walmsley, Jeff Anderson, Kristen Snare, Kevin Dang, Cedar Lehan, Frank Thorwald, Tennille Davis, Tariq Al-Nassif, and Les Braswell. Let the record reflect that the board members have been furnished copies of the complaint and notice of hearing and the pleadings of the record. Will the parties please introduce themselves, starting with the state?
Yes, thank you. Seth Hargraves, Assistant Attorney General on behalf of the state. Just one clarifying point. You said 12B, it's 28B.
Oh, I'm
correct?
sorry. Yes, I'm sorry.
Okay.
Is Mr. Neville present?
No, he's not. After receiving the consent notice of hearing, complaint notice of hearing, he signed a consent for voluntary surrender, which is in your packet, and the state would ask you to accept that consent to resolve this case and vacate the hearing.
Thank you, Mr. Hargraves. Board members, any questions, or do I have a motion?
I'll make a motion to accept the consent agreement and vacate the hearing.
Second.
Motion and a second. Any discussion? Dr. Gandhi.
Mr. Braswell,
Aye.
Mr. Thorwald,
Aye.
Ms. Nair,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Lehan,
Aye.
Mr. Dang.
Aye.
Mr. Al-Nassif.
Aye.
and Mr. Anderson.
Aye.
Ayes have it, Madam Chair.
This concludes this matter. 28C, I believe Ms. Lehan is recused from.
I have a quick question. Do we
Yeah.
need to accept the surrender as well, or is that,
That's in
was
this
that part of
consent.
the?
That was the voluntary surrender was the term of the consent, right?
Correct.
So it's been covered? Yeah. Yeah, just want to make sure.
Yes, due to my employment, I will recuse.
Okay. 28C, Keandra Destiny Whiting, board case number 24-0490. This is a formal administrative hearing to determine whether there have been violations of the board statutes and rules and whether disciplinary action is warranted. Board members present today include Lori Walmsley, Jeff Anderson, Kristen Snare, Kevin Dang, Frank Thorwald, Tennille Davis, Tariq Al-Nassif, and Les Braswell. Let the record reflect that the board members have been furnished copies of the complaint and notice of hearing and all pleadings of records. Will the parties please introduce yourselves?
Seth Hargraves, Assistant Attorney General on behalf of the state.
Is Ms. Whiting present?
I don't see her online, Madam Chair.
Ms. Whiting, if you're present, if you could please unmute yourself and introduce yourself for the record. No? Mr. Hargraves, would you like to go ahead?
Yes, thank you. Complaint notice of hearing was issued to Ms. Whiting, and she did respond. So we will proceed. Just as an overview, this case involves noncompliance with a board order. On April 19th of 2024, the board issued Ms. Whiting, holder of pharmacy technician training license, in order for non-disciplinary order for continuing education to resolve board case 23-713, which involved a patient receiving misbranded medication from CVS Pharmacy. The order was sent to Ms. Whiting's address of record by certified and regular mail and to her electronic mail account. The 3 hours of continuing education in the area of error prevention was required to be completed by August 7th of 2024. The order required that Ms. Whiting provide board staff with satisfactory proof of completion of the required CE within 14 business days of completing the CE. On August 14th, board staff reached out to Ms. Whiting by email regarding her failure to submit documentation of her completion. In the email, staff allowed Ms. Whiting until August 23rd to submit her continuing education. She did not submit proof of completion by the new deadline and did not respond. On September 6th, staff opened a new complaint against Ms. Whiting's license for violation of a board order. That day, staff sent Ms. Whiting a complaint notice and a request for response to the complaint. The notice was sent to her address of record by certified and regular mail and to her electronic mail account. She failed to respond or provide proof of completion of the CE. On December 16th, Ms. Whiting was sent a complaint notice of hearing to her address of record by certified and regular mail and to her electronic mail account. It was the same address, address of record, email account that all prior correspondence had been sent to. This time, Ms. Whiting responded that same day via email stating confusion as, according to her, she had responded to the initial complaint. However, that was not the issue in the notice of complaint. The issue was not complying with the board order. To date, she has not provided any documentation showing that she has complied with the board's order and completed the required CE. And with that, I will call Jennifer Mitchell as state's first witness.
Thank you. Ms. Mitchell, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Ms. Mitchell, could you please identify for the board your current occupation?
I am the executive assistant to the executive director.
And what does that entail?
I send notices of complaint, board meeting notices. I follow up on, or send out non-disciplinary orders and follow up on those orders and investigate cases of noncompliance.
Are you familiar with a licensee by the name of Keandra Whiting?
Yes, I am.
Are you familiar with the issues that we're here for today?
Yes, I am.
If you can look at what's been marked as States Exhibit 1, on starting on Bates page 2, and then for board members, board book page 5169. Do you want to identify this document for us?
That is a verification of Ms. Whiting's pharmacy technician trainee license.
And what is the current status of that license?
It's open.
And what is, when was it issued?
It was issued on November 17th, 2022.
And what is the expiration date on that license?
November 30th, 2025.
Now, could you give us a brief overview of why we're here today?
We are here because Ms. Whiting failed to comply with the non-disciplinary order for continuing education that was issued to her.
Okay. And looking at what's been marked as States Exhibit 2, beginning on Bates page 4, board book page 5171, is this that order for non-disciplinary CE?
Yes, it is.
Going to Bates page 5, when was this issued?
April 19th, 2024.
And according to this, it was sent by electronic, regular, and certified mail. Is that correct?
That's correct.
And the address it was sent to, is that Miss Whiting's address of record?
It is.
According to this, what was she required to do?
She was required to complete 3 hours of continuing education in the area of error prevention within 90 days of the effective date of the order.
Okay. And once she completed that, were there other requirements?
She was required to provide satisfactory proof of completion of the required CE within 14 business days of completing the CE.
Okay. Off the top of your head, do you know approximately when that 90 days would have been due?
I believe I put it in an email to Ms. Whitting, which I could find. It was due on August 7th, 2024.
Okay. And again, this was sent by regular, certified, and electronic mail, correct?
That is correct.
Looking at what has been marked as States Exhibit 3, Bates page 9, board book page 5176. You identify this document?
That is an email sent from staff to Ms. Whitting regarding her failure to comply with the order. and the opening of a complaint for violating that order.
So if we can just jump to Bates page 10, initially there was an email at the bottom there dated April 19th. Is that correct?
Correct?
And is that the email in which the non-disciplinary order was sent to her?
Yes, it is.
And going back to the previous page, Bates page 9, there's down the bottom, an email dated August 14th.
Correct?
And what is that email?
That is an email from staff to Ms. Whitting, letting her know that she had not complied with the order and providing her with an extension of time to provide the continuing education.
And according to this, what date was she given to provide that documentation?
August 23rd, 2024.
And then at the top of that page, there was a subsequent email, is that correct?
Correct?
And that one is dated September 11th, 2024.
Right.
And what is that email?
That is an email notifying Ms. Whitting that a complaint had been opened against her license for violation of a board order.
Okay. If we can jump to what's marked as States Exhibit 4, Bates page 12, Board Book page 5179. What is this?
That is a letter from staff to Ms. Whitting regarding notifying her that a complaint had been opened against her license and requesting a response to the complaint.
And was this letter attached to the email we just saw on Exhibit 3?
Yes, it was.
And did she respond to the notice of a new complaint?
No, she did not.
Jumping to States Exhibit 5, we have an additional letter.
That's correct.
And what is the date of this letter?
October 31st, 2024.
And what was the purpose of this letter?
It was to notify Ms. Whitting that the complaint that was opened against her would be forwarded to the Complaint Review Committee and the board for their consideration.
And it let her know what the dates and times of those meetings?
That's correct.
Your knowledge, did she appear?
Not to my knowledge. No.
Looking at what's been marked as States Exhibit 6, what is this?
That is staff summary about the complaint, outlining the when the complaint was issued, why it was opened, and the fact that Ms. Whitting did not respond to be presented to the board and the Complaint Review Committee.
Basically, it's a summary of the case and what the status of things were.
That's correct. Thank you.
And was this presented to the board at the for their consideration at the December meeting?
It was.
And what action, if any, did the board take?
The board voted the complaint to formal hearing.
And looking at what's marked as States Exhibit 7, is this the notice of hearing that was issued?
That's correct.
And how was this sent to Ms. Whitting?
It was sent by regular first-class mail, certified mail, and email.
Okay. And in this notice of hearing, was she required to respond?
She was.
And did she respond?
She did.
Looking at what's marked as States Exhibit 8, is this her response?
It is.
And was a response by email?
It was.
What was the date of the email?
December 16th, 2024.
And can you read her response for us? And actually, you can leave out the phone number.
It says, I'm very confused. I did write a paper and completed all courses. That is false information of me not adhering to the case. I understood how serious it was and wrote a paper expressing my fault, frustration from being the only tech with one pharmacist on a shift at a store I floated at from returning from Virginia for college break. You can call me anytime. I attached down below is the paper stating it. I am a full-time college student and I no longer work the pharmacy. But while being at the pharmacy, I immediately took action to the case. I never ran away from it. I follow every step that was given to me.
And in addition to this email, the following pages, Bates page 27 through 33, are these documents that she sent with that response?
And that's correct.
Do any of these show that she had completed the CE that was required by the order?
They do not.
As we sit here today, have you received, or to your knowledge, has the board received any documentation showing that she has completed the required CE?
No.
Madam Chair, I would move States Exhibits 1 through 8 into evidence.
I'll make a motion to approve.
Accept them into evidence.
Accept them into evidence.
Do I have a second? All those in favor?
Aye.
Any opposed? Hearing none?
State has no further witnesses.
Do you wish to rest your case?
Yes.
Board members, the board will now discuss whether the state has proven these allegations. Do you have any questions or discussion? Is there a motion with regards to the factual allegation and the alleged violations on the complaint notice of hearing?
I move that we accept the factual allegations and vacate. No, not vacate, sorry. I move we accept the factual allegations.
I'll second.
I have a motion and a second. Any discussion? All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Is there a motion with regards to the discipline?
Madam Chair, I believe that motion was just for the allegation, factual allegations. Mr. Harris can correct me, but I believe you still need to address the
Conclusions of law.
violations.
Charges to be accepted as your conclusions of law.
I move to accept conclusions of law.
Is that appropriate?
Second.
Yeah, it's to adopt the notice of charges as your conclusions of law.
I'll make that my motion.
Thank you.
Yeah, second.
All those in favor?
Aye.
Any opposed? Hearing none. Discipline? The state is recommending revocation.
That I'll leave it to the board's discretion. At this point, you issued an order for CE that has not been completed. I'm not sure at this point what else, can be done. Maybe revocation is appropriate. I will defer to the board on that.
Can I ask a question of Ms. Mitchell? Prior to the December 16th email, had you heard from Ms. Whiting?
No.
Thank you.
I'll make a motion for revocation.
Second.
Any discussion? Dr. Gandhi?
Mr. Braswell,
Aye.
Mr. Thorwald,
Aye.
Ms. Nair,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Lehan is recused. Mr. Dang,
Aye.
Mr. Al Nassif.
Aye.
Mr. Anderson.
Aye.
Ayes have it, with one recusal, Madam Chair.
Thank you, Dr. Gandhi. This concludes this matter. The board's decision will be reduced to written order. Thank you for attending. I will turn it over to Mr. Anderson for 12D.
Thank you, Ms. Walmsley. This is 28D. Safia Renee Grant, board case numbers 24-0152 and 25-081. This is the date, time, and place where this matter is scheduled to be heard by the Arizona State Pharmacy. This is a formal administrative hearing to determine if there have been violations of board statutes and rules and whether disciplinary action is warranted. Board members present today include Jeff Anderson, Kristen Snare, Kevin Dang, Cedar Lehan, Frank Thorwald, Tennille Davis, Tarek Al Nassif, and Les Braswell. Let the record reflect that the board members have been furnished copies of the complaint, notice of hearing, and all proceedings of record. Will the parties please introduce yourselves, starting with the state?
Yes, thank you. Seth Hargraves, Assistant Attorney General on behalf of the state.
And Ms. Grant, would you please introduce yourself?
Can you hear me? My name is Safia Grant.
Hi, Ms. Grant. Do you have an attorney?
No.
Right. You do have the right to be represented by an attorney, but the law does not provide for the appointment of counsel on your behalf. If you want an attorney, it is your responsibility to secure and pay for one. By proceeding without representation of legal counsel, you are waiving your rights. This hearing is your opportunity to present testimony and evidence on your behalf. And if you appeal the board's decision, the record you make at this hearing today will be the evidence considered by a court in determining whether the board's decision was proper. Do you understand what I've told you, and do you wish to proceed without counsel today?
I do.
A hearing of this nature differs from a court proceeding. The technical rules of evidence do not apply. Reliable hearsay evidence is admissible. The board will entertain objections concerning irrelevant, repetitious, and otherwise inadmissible evidence. Each party will be allowed to present evidence, cross-examine opposing witnesses, and make a closing argument. In a disciplinary proceeding, the state bears the burden of proof and shall present its case first. Each party may now make an opening statement. This is a brief summary of the case you intend to present today. Does the state wish to make an opening statement?
Yes, thank you. This hearing involves two separate cases against Safia Grant, both involving her noncompliance with the board order. On October 25th, 2023, the board issued Ms. Grant, holder of pharmacy technician trainee license, an order for a non-disciplinary civil penalties in the amount of $500 to resolve board case number 22-0741, which involved her failure to disclose criminal charges on board applications. The order was sent to Ms. Grant's address of record by certified and regular mail and to her electronic mail account. She responded that same day via email stating, "Received, thank you." The civil penalty imposed by the order was to be paid by February 28th, 2024. Ms. Grant failed to pay the civil penalty. Board staff reached out to her by email on February 29th, 2024, letting her know that there was no record that the civil penalty had been paid and asking her if she had submitted it. She did not respond. On March 11th, board staff opened a new complaint, case 24-0152, for violation of a board order. That day, staff sent Ms. Grant a compliance notice and request for response to the complaint. The notice was sent to her address of record by certified and regular mail and to her electronic mail account. He responded to the notice on March 19th. In the response, she requested an extension to pay the civil penalty and was given an extension until April 15th. He failed to pay the civil penalty. On or about June 21st, the board issued Ms. Grant a complaint notice of hearing, notifying her that her matter was scheduled for a hearing before the board on August 22nd. Complaint notice of hearing notified her of her obligation to respond, and that if she failed to do so, the board could deem the allegations admitted and take action without conducting the hearing. On July 29th, the state filed a motion to deem the allegations admitted due to her failure to respond to the complaint notice of hearing. On July 30th, Ms. Grant replied to the state's motion to deem. In a response, she apologized for the late response, indicating that she was homeless for the past 7 months, had not received the notice of hearing by mail. The response did not indicate that she had not received the notice by other means, such as email. Again, at this point, all correspondence orders were sent to the exact same addresses and email address. On August 22nd, Ms. Grant appeared before the board. In that appearance, she stated the address on file is still her mailing address at which she has access to mail. She asked for more time to pay the civil penalty. The board denied the state's motion to deem and continued the hearing to a future board meeting. As of today's date, she has still not paid the civil penalty. On November 4th, 2024, staff opened a new complaint on Ms. Grant, case 24-0581, after receiving information from her that she had been arrested in Texas on March 4th, 2023. Her disclosure was not timely under ARS 32-3208. According to the documentation that she submitted, which was from the Lynn County, Texas Sheriff's Office, she was a passenger in a vehicle that was stopped on March 4th, 2023. During the stop, officers noted a strong odor of raw marijuana coming from the vehicle, and the driver acknowledged having smoked marijuana with the passengers prior to the stop. Ms. Grant, who was not the driver, was found in possession of cocaine, a dollar bill and straw with residue that tested positive for cocaine. Officers also found a clear plastic bag with 5 pills that Ms. Grant identified as ecstasy. Ms. Grant took ownership of the suspected narcotics. Due to the seriousness of the allegations that were outlined in a police report on November 4th, Ms. Grant was issued an interim order for drug screening pursuant to ARS 32-1927.01F. The interim order required her to provide a urine and hair sample for drug screen testing at a laboratory no later than 5 p.m. on November 6, 2024. On November 7th, board staff attempted to contact Ms. Grant regarding her compliance. No response was received. Staff attempted contacting her again on November 12th. She responded on November 14th and indicated that she is willing to undergo a urine test, but was not willing to provide a hair sample. She also stated that she would be in Tennessee until the beginning of December to deal with personal matters and was not unwilling to comply, but was not available to do so. The issue of her noncompliance with the interim order was considered by the board at the December 11th meeting. She appeared virtually and had not provided a urine or hair sample at that time. The board voted the matter to hearing. As we sit here today, the board has still not received any test results showing that she has undergone the required or requested urine and hair sample. The evidence and testimony that will be introduced will show that she has failed to comply with 2 board orders and that discipline is warranted in this case. Thank you.
Thank you, Mr. Hargraves. Ms. Grant, would you wish to make an opening statement?
Yes. So, honestly, I don't make a lot of money, so I don't really have extra money to pay that fee. And I've just been waiting on a response. Basically, like, we've had a hearing. It was, I'll get back to you on what happens next. And then I reported what happened with me. That stopped. I took ownership for what was in that vehicle because my child was in that vehicle. I think that I explained this before, right? And I didn't want the people that were in the vehicle to be held liable because somebody had to take care of my kid, right? I'm going home for a funeral because my uncle passed and then a kid of mine passed. So I'm just moving. I took responsibility for whatever was there. It didn't matter if it was mine or not. I'm not going against what you all want or require. I'm just waiting on instructions. It's a hearing and then we'll get back to you. It's a hearing, we'll get back to you. If you want me to go and get testing, I'll go and do that. My trainee license is about to expire right now. I can go and take a test for the state board, for the Arizona board. I will pass it. I haven't worked in my field since the incident in Texas because I didn't want to mess up anything with my license. It's very important. I worked on this. I'm not trying to go against the grain. I'm not trying to not do what you want or require to keep my status going. I've actually stepped back so that I didn't damage what I worked for. I don't got a lot of money. I make $16 an hour right now, and I take phone calls at home. So I don't have to go outside. I don't have to get in no trouble. Like, I'm trying to get my life together. I did take a loss to protect. I just don't want to be penalized for that. If you can understand that. That's it.
Thank you, Ms. Grant. Mr. Hargraves, could you please call your first witness?
Yes, state calls Jenica Brown.
Ms. Brown, please, do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Ms. Brown, could you please tell us what your current occupation is?
I'm the executive assistant to the deputy director.
And can you give us a brief overview of what that entails?
Yes, I handle administrative matters leading up to and following board meetings. I also investigate complaints related to substance use and abuse, mental health, fitness for duty, diversion, impairment while working, unprofessional conduct, any complaint really that a licensee is an imminent threat to the safety and welfare of the public.
Are you familiar with the two cases we're here for today involving Ms. Grant?
I am.
How are you familiar with them?
I investigated the second complaint.
Have you reviewed both of those cases prior to today's hearing?
I have.
Can you just give us a brief overview, description of what the issues are for each case?
Yes. So this matter is comprised of two complaints that were combined. Complaint number 22-0741 was open to address Ms. Grant's failure to notify the board of charges within 10 days. The board considered that matter during the October 2023 meeting and voted to issue a non-disciplinary civil penalty in the amount of $500. Ms. Grant did not pay that civil penalty, and so a second complaint, 24-0152, was open to address her violation of a board order, which was considered during the June 2024 board meeting. The board then voted to move the matter to hearing, which was set for August of 2024. During that hearing, the state filed a motion to deem. The board denied that motion and voted to continue the hearing to the October 2024 board meeting. While staff was preparing for that continued hearing, we became aware of the incident that occurred in Texas in March of 2023, where Ms. Grant was arrested and charged with possession of controlled substance, prohibited substance, tampering with evidence, and unlawful carrying of a weapon. I investigated that complaint. Ms. Grant did not report the charges to the board within 10 days, so staff opened a complaint and issued an interim order for drug screening due to the seriousness of those charges. Ms. Grant did not comply with the interim order, and the matter was considered during the December 2024 board meeting. The board voted to combine both of her complaints and set them both for a hearing. We're here today for that hearing.
Okay. If you can take a look at what has been marked as State's Exhibit 1, can you identify this document?
This is a certification of Ms. Grant's pharmacy technician trainee registration.
Okay, and according to this, when was her license issued?
It was issued on April 21st of 2022.
And when does it expire?
It expires on April 30th of 2025.
And if you can take a look at what's been marked as State's Exhibit 2, State's page 4, Board Book 5216. You identify what this is.
This is an investigative report.
And for what is the complaint this is a report for?
This is for complaint number 22-0741.
And what are the allegations of this complaint?
This complaint outlines two instances in which Ms. Grant failed to report charges within 10 days, and it also addressed her failure to disclose charges on an application.
Okay. And is this an overview of the case that was presented to the board for consideration?
It was.
And did the board take action as a result of this complaint?
They did.
And just looking at the top of this, what is the date of this report?
July 7th, 2023.
Okay. Jumping now to what's marked as State's Exhibit 3, dates page 7, Board Book 5219. What do we have here?
This is a letter issuing an order for a non-disciplinary civil penalty to resolve board case 22-0741.
And what is the date of the letter?
It was dated October 25th, 2023.
And the letter references an enclosed order for non-disciplinary civil penalty?
It does.
Looking at that next page, what is the order?
This is an order for two $250 fines for failing to provide notice of a criminal charge, arrest, or conviction in any jurisdiction.
And according to this, what was the amount of the civil penalty?
$500.
And according to this, when was it required to be paid?
Within 90 days from the date of issuance.
The date of issuance on the bottom states October 25th, 2023.
Correct.
And subsequent pages to that, there's an email correspondence regarding the order.
Yes.
We jump to Exhibit 4, dates page 11. We have email string, is that correct?
It is, yes.
Okay. Looking at the bottom, there's that email we just looked at from October 25th, referencing the attached order, is that correct?
Correct.
And just above that, was that did Miss Grant respond?
She did.
And when was the initial order by email sent?
October 25th, 2023
At what time?
at 8:01 a.m.
And her response is listed right above that?
Yes.
And when was the response received?
On October 25th, 2023 at 8:51 a.m.
50 minutes after it was sent?
Correct.
And what was the response?
Received,
Wait,
thank you.
days later.
You can jump and look at what's been marked as Exhibit 5, dates page 14. What do we have here?
This is a notice of complaint in board case 24-0152.
And what is the date of the letter?
It is dated March 12th, 2024.
And what does it indicate?
It indicates that a complaint was opened for violation of a board order.
And the board order references case 22-0741, is that correct?
Correct.
And what is the new complaint number?
The new complaint number is 24-0152.
And looking at the second page, email, is that correct?
Correct.
Is that showing that that correspondence was also sent by email?
Yes.
We can just take a quick second. I gotta grab my charger. Apologize.
Do we have to go through and speak for these? Because
Looking now, it's when marked as States Exhibit 6. Again, we have email strings, is that correct?
That's correct.
And looking at the email at the bottom, March 12th, what was this email stating?
This email stating that a complaint was opened against her license and it is requesting a response to the complaint.
Okay, and did she respond to that?
She did.
And just above that March 12th email is an email from Ms. Grant?
Correct.
And when was that email received?
On March 19th, 2024 at 8:05 a.m.
And what was that response?
She stated that she left a message for staff explaining that she would need extra time to pay the fee. She needs an extension until April 15th, 2024.
And did staff respond to that email?
She did.
And looking up at the top, there's a responsive email dated March 19th, is that correct?
That's correct.
And what was the response?
The response indicated that the extension request was approved.
And did it give a time frame to which the extension applied to?
Yes, April 15th, 2024.
To your knowledge, did she pay the civil penalty by that date?
Not to my knowledge.
So what happened at that point?
The matter was moved to the board for consideration during the June 2024 meeting.
Taking a look at what's marked as States Exhibit 7, base page 19, what is this document?
This is a notice to Ms. Grant indicating that her matter would be considered at the Complaint Review Committee on June 11th, 2024, and then considered by the board during the June 2024 meeting.
And looking now at States Exhibit 8, what do we have here?
This is an investigative report.
That's in regards to complaint 24-0152.
Correct.
And was this provided to the complaint committee and the board?
It was.
And this provides a summary of the case at that point, correct?
Correct.
And this was provided both to the complaint committee and the board?
Yes, it was.
And what happened at those meetings?
During the June meeting, The board voted to move the matter to a hearing set for August.
And looking at what's been marked as State's Exhibit 9, is this the complaint notice of hearing for that matter?
Yes, it is.
And it notifies her on Bates page 24, the hearing will be held on August 22nd.
Yes, it does.
Looking at the next page, Bates page 25. Is she, any indication in here that she has any requirements in regards to the notice of hearing?
Yes, she's required to prepare and file a written answer within 30 days.
Did she do so?
Not to my knowledge.
So if you could take a look at what's marked as Exhibit 10, what do we have? The base page 32. What is this document?
This is a motion to deem allegations in complaint and notice of hearing as admitted and a motion to vacate the hearing.
That was filed by the state.
Yes, it was.
Was that presented to the board?
Yes, it was.
And was also copy sent to Ms. Grant?
Correct.
You can look at what's been marked as State's Exhibit 11. You identify this document?
This is an email response from Ms. Grant. The response was to the motion to deem.
Okay. Can you summarize her response for us?
She indicated that she was experiencing homelessness and did not receive the notice of hearing by mail. She requested for the board to consider her circumstances.
Okay. At this point, had all previous correspondence orders been sent to the same addresses, residential and email?
Yes.
And was this her response presented to the board?
Yes, it was.
And could you give us a brief overview or summary of what occurred at that meeting? Well, first of all, did she appear at the board meeting?
She did.
Okay. Could you give us a kind of brief overview of what occurred at that meeting?
Yes, she appeared in person and testified that she was experiencing difficulties with respect to her housing situation and that she has not ignored what she needs to do, but did not have the means. She stated that her mailing address is for someone that she can get mail from. And she stated that she got a new phone that she could use to communicate with staff. She had also requested more time to pay the civil penalty.
Okay. And what's marked as Exhibit 12, that's the video from that board meeting, correct?
Correct.
We got a couple clips from that. I'd like to play clip 1 first, please.
My housing situation hasn't been okay. So it's not like I've ignored what I need to do. I just haven't had the means to do it. And I did explain that in my answer back to him. So the address on file is basically right now my mailing address. I do have someone that lives there that can get me the mail, but I'm not always able to get to it. I just got a new phone as far as like emails, receiving those. So I would appreciate if you would just give me a little bit more time to pay that fine. I'll get it done. I don't want to lose my license. I worked very hard for that. So that's my stand on it.
Like play clip 2 as well, please.
Miss Grant,
Yes.
you will receive notice of that, but can you make sure that you provide the board with your current contact information, the best way to reach you?
So everything is still the same. It's just as far as mail goes, I might get it a little bit delayed, but you can still send mail to the same address. But I do have a question. If I'm able to pay this fine by the time this hearing comes back around, would that suffice the board or?
I can't answer that question. What I would ask you to do is reach out to Mr. Hargraves.
Mm-hmm. This gentleman?
Yes.
Okay. All right. No problem.
Thank you.
Thank you, Ms. Grant.
So that was the August 22nd meeting, correct?
Correct.
And she indicated that the address we have on file is the accurate address where she can receive correspondence, correct?
Correct.
And she asked for the ability to still pay the civil penalty, correct?
Correct.
That was August. We're here today, February 13th. As we sit here today, has she paid the civil penalty?
Not to my knowledge.
So that was the first case. Now, could you give us a little description of overview of the second case?
While staff was preparing for the continued hearing, Ms. Grant emailed staff and indicated that she had been arrested in Texas.
Okay, and looking at what's marked as State's Exhibit 13, base page 42, is that the email you're referencing, the communication you're referencing?
Yes, it is.
Okay, and looking at the bottom, what is the date of the email from her?
August 29th, 2024.
And according to this, could you just read the email?
It states, "Hello, my name is Safia Grant. I am sending documents to report an incident that occurred out of state. If there are any further questions, please let me know. Thank you for your time."
And did she provide any documentation with this email?
She did.
And is that documentation contained within base pages 44 through 47?
Yes.
And can you just kind of walk us through those and kind of summarize what those are?
Certainly. On page 44, this is a probable cause affidavit issued by Lynn County Sheriff's Office. This indicates possible charges related to prohibited substance.
Well, let me just stop you for 1 second. On Bates page 44 at the top, on that report, there is a stop date and time. Is that correct?
That's correct.
And what was the date of this interaction with Lynn County Sheriff and Ms. Grant?
March 4th, 2023 at 12:31.
And that's what she reported to the board on August 29th of 2024?
Correct.
Okay. Continue with your summary, please.
So there are charges outlined on this probable cause affidavit related to prohibited substance, fabricating physical evidence, carrying a weapon.
Okay. And the second page, page 45, is a narrative. Is that correct?
Yes, it is.
And is this a narrative from the deputy of the sheriff's office?
Yes, it is.
And did you review this when it came in?
I did.
And could you walk us through there and kind of point out any things that drew your attention or caused concern?
Yes, in the report, it indicated that the officer could smell a strong odor of raw marijuana coming directly from the vehicle, so he searched for contraband. The passenger was identified as Safia Grant, and there is an indication in here that she placed her hand back to the rear seat where the rear passenger was seated and handed her a bag with a green butter substance. He also stated that he observed her removing an object from the vehicle and placing it in the front portion of her pants. There is an assertion here that she confessed to placing cocaine inside of her pants, and she removed a $1 bill of United States currency and a straw, which were commonly used to snort the substance. The substance was later field tested positive for cocaine. He also located drug paraphernalia commonly paired with the use of cocaine, including five pills in a clear plastic bag. Miss Grant advised that they were ecstasy. He also located a black handgun. It is also indicated that Grant took ownership of the firearm and the suspected narcotics.
So after reviewing this information from Ms. Grant, what if anything did staff do?
It raised concerns of potential substance use. So we issued an order for drug testing, an interim order.
Okay. And was a new complaint file opened as a result of that?
I don't believe so.
Well, let's take a look at what's marked as Exhibit 14. Could you identify this document?
This is a notice of complaint.
Okay, and this was sent by you to Ms. Grant?
It was
And what is the date of it?
November 4th, 2024.
And this indicates that the board had opened a new complaint?
Yes,
And you requested a response, correct?
I did.
And with this notice of complaint, she was also sent a subpoena for records, is that correct?
She was.
And was she requested to respond to that?
Yes, she was.
And when was the response due?
November 18th, 2024.
Did she, to your knowledge, did she respond?
She did.
Okay, looking at what's marked as States Exhibit 15, could you identify this document?
This is an email chain between myself and Ms. Grant regarding her complaint and subpoena responses.
Okay, and what was her response? Well, first of all, looking at Bates page 58, at the bottom, we have your November 4th email with the notice and the subpoena. Just above that, when did she respond?
She responded on November 4th.
Okay, and what was her response?
She stated that she submitted all documents and information about the case a few months ago.
So at that point, did you receive any further documentation or information from Ms. Grant regarding the incident in Texas?
I did after I requested a response to the subpoena.
And what did you receive?
I received an order for dismissal from the Lynn County, Texas County Court.
So the criminal charges in Texas had been dismissed.
Yes,
And looking at this order on page 57, the order was as of March 25th, 2024, correct?
correct.
Now, you said before that the information in the police report raised some concerns.
Yes.
And again, what were those concerns?
Concerns related to substance use, potential substance use and abuse, and fitness for duty.
Okay. And again, what, if anything, was done as a result of those concerns?
An interim order for drug testing was issued.
Looking at what's been marked as States Exhibit 16, is that the interim order?
Yes, it is.
And looking at Bates page 67, it was signed by Director Gandhi, correct?
It was
And what was the date?
November 4th, 2024.
Going to the previous page, Bates page 66, what was being ordered?
Ms. Grant was required to provide a urine and hair sample to a drug screening laboratory test to test for legal and illegal substances, including controlled substances, no later than 5 p.m. on Wednesday, November 6, 2024.
Did you receive any response from Ms. Grant regarding the interim order?
I did not.
Did you receive any results of any testing?
I did not.
So looking at, with no response, what, if anything, happened next?
I sent a follow-up email to Ms. Grant to follow up on her compliance with the interim order.
And is that what is contained within States Exhibit 17?
Yes.
Okay. Looking at these emails, we'll start on Bates page 70. At the bottom is the November 4th email with the interim order, correct?
Correct.
And then you said you followed up. Is that the next one above that?
Yes, it is.
And what is the date of that email?
November 7th, 2024.
And can you just kind of summarize what your correspondence to her was at that time?
This is an email following up on her compliance with the interim order.
And you asked if she had complied with the order, correct?
I did.
And did she respond to that email?
She did not.
Okay, so going to Bates page 69, at the bottom, there's another email from you dated November 12th. Is that correct?
Yes, it is.
And what was that email?
I was following up on my follow-up email and requested a written response by November 13th, 2024.
Did she respond to that email?
She did.
And is that response right above that one?
Yes, it is.
And what was her response? When did you receive that response?
November 14th, 2024 at 7:14 a.m.
Okay, and what was her response?
I'm not sure why I'm being tested when the paperwork clearly shows that the case was dropped for lack of evidence. I am willing to give a urine sample, but I'm not willing to give any hair samples.
And above it shows that you responded to her?
I did.
And what was your response?
I acknowledged receipt of her response and notified her that as she has not complied with the interim order, the board would consider her noncompliance at the December 2024 board meeting.
And above that, she responded to that email from you?
She did.
And what was her response?
Okay, thank you. Can you also put in your notes that I am not in the state at the moment? I've been in and am still currently in Tennessee dealing with 2 deaths in my family and will be here until the beginning of December. Not that I won't comply, just not available to do so.
So with that response, what, if anything, did you do?
I prepared her matter for the December meeting.
Okay, and was she notified of that?
She was.
Looking at what's been marked as States Exhibit 18, you identify this document.
This was an email sent to Ms. Grant requesting her appearance at the December 2024 board meeting.
Okay. And it was sent to the email address that other prior notices have been going to?
Yes, it was.
Looking at what's been marked as Exhibit 19, what do we have here?
This is an investigative report for complaint number 24-0581.
And was this report provided to the board at their meeting regarding this case?
Yes, it was.
And does this summarize kind of what you've testified to here today regarding summary of this case?
Yes, it does.
Did she appear at that meeting?
She did.
Was she in person or virtual?
She was virtual.
Could you summarize what occurred at that meeting?
During that meeting, I presented to the board a summary of this case regarding Ms. Grant's failure to report charges from March of 2023 and the failure to comply with an interim order. Ms. Grant did not provide a statement prior to questions. She was asked why she was not willing to submit a drug test, and she stated that she was not unwilling. She just had dyed hair, and due to being African American with the dyed hair, she wasn't sure how it would affect the results. She said that she was not unwilling to provide a urine sample, but thought that she had to do both the urine and hair, which is why she did not complete the drug screening. She stated that she didn't report timely because she was in jail in Texas. She has not done any work in pharmacy since the incident in Texas, and she discussed things that were going on in her life, such as her daughter's passing, being in jail, not having a job, not having anywhere to live, all of those things being factors in her reporting late.
The interim order that was issued to her, did it specifically require that the testing needed to be done within the state of Arizona?
No, it did not.
Okay. And one of the reasons that she had stated in her response for not complying was because she was in Tennessee, correct?
Correct.
To your knowledge, are there testing facilities in Tennessee?
Yes.
And if you can take a look at what's been marked as Exhibit 21, kind of looking at base page 88, you identify what this indicates?
And this is a list of collection sites in Tennessee for drug testing.
It lists several cities or towns, correct?
Yes.
And within each one, it identifies how many locations are available for testing?
Correct.
Now, you said she appeared at the meeting. I would like to have clip 3 played, please, from that meeting.
Board members, the floor is open for questions.
Ms. Grant, why are you unwilling to provide a hair sample?
I- Honestly, I do know that I am an African American person and that chemically, like I have a lot of dye and things in my hair. I don't know what it may come out to be as far as that testing. Um, I was on probation and had to do random drug tests uh, throughout that year, which ended basically when I came in on my birthday, August 16th of 2024 is when my probation ended. Um, I haven't had any dirty drops or anything like that. So if I'm able to give you a urine sample and provide through the state those drug testing results, then I can do that. But that's my response on that. I'm sorry.
So to clarify, you've dyed your hair and thought that that would mess up the result of the test? Is
Well,
that-
my hair has been constantly dyed, like different chemicals. So I'm not sure if that would have any type of negative effect on the results. Yes, ma'am.
Ms. Grant, as a follow-up question, you were ordered to submit a drug test before November 6th. Today is December 11th. Why did you not at least submit a urine before November 6th?
I had no problem with that at all. I can't tell you why I didn't go and just do the urine. I have no real reason why it wasn't no, I'm not going to do it. I just thought that I had to do both, and that was the reason why.
If we can play clip 5, please.
Reporting in an untimely manner, like I was actually in jail
Actually,
in
clip
Texas. The
clip
last job that I worked. It wasn't like, no, I don't want to comply. That is not
But you said you're
yes.
not willing to do the test that we asked for you to do. That
Well,
is something you don't
I
wanna
don't
comply.
want I don't want to submit a sample that would possibly come back that is not correct. And I do understand there are things that you can go through to like if it came back inconclusive or whatever about my hair.
So
Basically, I'm
when the interim order was issued, it asked for urine and hair, correct?
Correct.
What was the purpose of requesting that the hair be tested?
A hair test can detect substances that were used further back in time than a urine sample.
And when she appeared at the board, she said she was willing to do the urine, but not the hair, correct?
Correct.
And that was at the December meeting.
Correct.
As we sit here today on February 13th, have the board received any results of either a urine or a hair sample regarding Ms. Grant?
No.
So at that board meeting, the board voted the matter to hearing, correct?
Correct.
And looking at what's been marked as States Exhibit 22, is that the notice of hearing for today's case?
Yes, it is.
And it's amended incorporating both cases, correct?
Correct.
And as with the other one, was she required to respond to this?
Yes, she was.
To your knowledge, has she responded to the notice of hearing for today's hearing?
Not to my knowledge.
At this point, I would move exhibits 1 through 22 into evidence, please.
Thank you, Mr. Hargraves. Ms. Grant, do you have any objection to that evidence being submitted?
Okay, so let's go back to the first case with the DUI, right? This was something that happened.
Ms. Grant, can you pause for Mr. Harris? What's appropriate right now for her, how she be responding?
Yeah, thank you. The only question before her right now is if she has any objections to any of the state's exhibits. So Ms. Grant, if you could simply answer that question, you will be given an opportunity to address the state's case in a moment.
Exhibits, like what do you mean exhibits? Like the emails and things of that nature?
That's correct. Everything that was just read.
Oh yes, so it is what it is. Yes. The emails are the emails. It's correspondence. Yes.
Thank you, Ms. Grant. Board members, do we have a motion to accept the evidence?
I'll make a motion to accept the evidence submitted.
Second.
All in favor, please say aye.
Aye.
Any opposed? Okay, motion carries. Thank you.
State has no further questions and no further witnesses. Thank you.
Thank you, Mr. Hargraves. Ms. Grant, do you wish to cross-examine the witness?
Who is the witness? The lady right here?
Yes, Ms. Brown.
I don't really have any questions or cross-examining. I just have what I have to say. As far as like the first case that was brought up with the DUI, that happened in a moment like COVID,
Ms. Grant,
right?
Ms. Grant,
I'm sorry.
Can you please hold? This is not the time for that.
Oh,
What time is what do you want to hear from me? Because I'm just going to tell you there were
Ms. Grant.
life is life. Excuse me. I'm sorry. Life is
We
life.
just need
right?
to, you're
And
going to be
I
given.
haven't tried to put anything past anything, but
Ms.
life
Grant.
is life. And
Ms.
I
Grant.
haven't worked in my field. I haven't done anything unethical or out of like I haven't done anything wrong as far as
Ms. Grant,
working
this is
the
Mark
pharmacy.
Harris. You'll be given an opportunity to present your case to the board. However,
Okay.
we're going to need to place you under oath before you do so. If you're going to be, thank you.
Thank you, Mr. Harris. Board members, do you have any questions? All right, State, Mr. Hargraves, do you rest your case?
Yes.
All right, Ms. Grant, do you have any witnesses?
Me?
Okay. Do you solemnly
But I do have a witness. I have somebody that was in the car with me while I was in Texas. Is that a viable witness?
do you have a
to my-
witness with you here today?
Yeah, she's here.
Is that appropriate? All right.
We would
Ms.
just
Grant, would you like to present your witness?
Yes, give me 1 second. Hey, Dominique, I need you. Okay, so this is Dominique Warfield. Hello.
Hi. Welcome.
So-
Can you please introduce yourself for the record?
My name is Dominique Warfield.
All right. And do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do.
All right. Please go ahead.
So what am I supposed to be doing? I'm just gonna ask you my questions, I guess. When we were in Texas, can you just tell them what happened, I guess? I don't know when we got pulled over. I'm just dealing with my case right now.
It was multiple people in the car. It was myself, her, and another young man and our daughter. And we were pulled over for speeding, and they found a firearm, and I was told residue of cocaine, and she was the person in the passenger seat. The person who was driving the vehicle was not apprehended. They asked everybody whose was what, and she took the weight of the whole entire thing by just saying, like, you know, I have my child with me. I'm gonna go ahead, and thinking it's gonna be like an easier situation the way the police brought it to her, as if you say this is yours, we can just go book you in and you guys can get out type deal. And that was not the case. They held her for about 28 days, and they dropped the charges because they couldn't hold it, or it couldn't stick. Like, it wasn't enough evidence, or it wasn't anything that was of enough value.
Thank you. State, do you wish to cross-examine in the witness?
Do you want to see if if Ms. Grant has further questions of her, or?
Ms. Grant, do you have further questions of your witness?
No, I just wanted her to tell you guys actually what happened.
Okay. I do have a couple of questions. What is your relationship with Miss Grant?
This is my girlfriend.
Okay. And you were in the car in Texas?
Yes.
And you just testified that Miss Grant told the police that the drugs were hers, correct?
Yes.
No further questions.
Okay.
Ms. Grant, do you have any other witnesses?
I don't have any other witnesses. It's okay, you can go.
Just to remember, if she is going to testify, be sworn in. Yeah.
If you would like to provide testimony, you yourself need to call yourself as a witness.
Okay, well, I'll call myself as a witness. You can
Okay. Let me swear you in. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do.
All right. Thank you, Ms. Grant. Go ahead.
So basically, I got 2 charges, one for the DUI, one for the thing in Texas. The DUI, I didn't know what was what with that charge. I got a notification that I had to go to court the same time you guys were notified I had to go to court. It's like a back and forth thing. So I didn't know it's in the middle of COVID. I didn't know I didn't get no ticket. I got pulled over and then I got let go. I didn't hide anything because I didn't know what was what. I explained it at the first hearing for the DUI. I take responsibility for everything that I do. I took responsibility to keep everybody else out of trouble. And I'm messing myself up. I'm messing what I work for. I'm messing it up to save other people. To make sure that people is okay. I ain't hiding nothing.
Thank you, Ms. Grant. Do you have
I
any
didn't
other?
hide anything about Texas. I didn't even know what was going to happen with Texas. At the time that I notified you, like with the court, the hearing in August, I'm like, oh, yeah, I got a lot of going on.
Thank
And
you,
it's
Ms.
like,
Grant.
oh, well, you
Do
better
you have
tell
any
them.
other testimony to share outside of the
Yeah,
Texas case?
no, I don't. Yeah, no.
State, do you wish to cross-examine this witness?
Yes, just a couple of questions. Ms. Grant, are you saying that you lied to the sheriff's deputy in Texas regarding the drugs?
I ate it. Yeah. If you want to say I lied, then I lied. I ate it.
What do you mean you ate it?
I
You
took
talking about the drugs?
No. What I mean by when I say I ate it, I took responsibility to make sure nobody else got in trouble.
But you told the police that the drugs that were found were yours, correct?
They found drugs in the car. I had a 13-year-old daughter in the car, and they were talking about searching my kid. So yes, I did tell them that it belonged to me. The gun was mine because I'm not a felon, and it was legal, and it's legal. I owned it.
Okay. Now, you were issued a non-disciplinary order for a civil penalty. Have you paid that civil penalty?
No, I don't got no money.
Okay. And you were issued an interim order to submit to a urine and hair test. Have you completed that?
No, because I'm waiting on what y'all want me to do. The lady right there just said continuance. We're gonna go to another hearing. I don't know what, like, in between these hearings, what am I supposed to do? What do you want me to do?
Okay.
Just tell me and I'll do it. Like, I don't know, if you tell me we're going to another hearing, then that's not like, that's leaving me hanging by a string. Like, we'll give you instructions after a while.
Okay. You appeared at the August 22nd hearing, correct?
Correct.
And that's where the issue was the non-payment of the civil penalty, correct?
Correct.
And you saw the video clips from that meeting, that hearing?
Correct.
And in that, you asked about the ability to still pay that penalty, correct?
Correct.
That was in August of 2024, correct?
Yes.
Have you paid that as of we sit here today?
No, I haven't, because
Okay.
I didn't get no solid answer on that. Right?
And you were
They
here in
just told
December.
me we're gonna have another hearing on it.
And you were here in December, correct?
Virtually, yes.
Okay. And at that time, you said the time frame to submit the urine and hair test had already passed, and that was the issue that the board was looking at. Do you recall that?
I do recall.
And you stated at that meeting that you were willing to take the urine test, but you weren't willing to take the hair test, correct?
I do recall that, yes.
Okay. And as we sit here today, 2 months later, have you completed either of those tests?
I did not, because I was
No further
told
questions.
we're going to have a hearing, again, another hearing.
Thank you, Mr.
So
Hargraves.
I don't know which way to move, right? And I don't want to move the wrong way. So if you tell me what to do, then I can do that.
Ms. Grant, do you have any other testimony or have any other witnesses you'd like to call?
No, I don't. I'm just,
Ms. Grant, do you rest your case?
I guess so.
All right, this concludes the evidentiary portion of the hearing. The board will now hear closing comments. The state may make a closing argument.
Thank you. The evidence and testimony that have been submitted here today show 2 instances where Ms. Grant was issued an order by this board and she has not complied. The first order, the non-disciplinary order for continuing education, was a result of her failure to disclose on applications to this board. That started, I believe we're well past, that order was issued in 2023. She has stated several times she's willing to pay. She's asked for extensions. She's been granted extensions. It hasn't been paid. Then we have the second case where she, about a year later, reports charges in Texas regarding a report where she told police that drugs found in a vehicle belonged to her. She's saying that she lied to the officers about them being hers. Staff looked at the information that was provided, had concerns about whether, she's using drugs or not, issued an interim order to get clarification of that. She didn't comply. She's told this board that, she's willing to do one, but not the other. And the one that she's willing to do is required to be done by November. Here we are, several months later. She's saying she's willing to do it. She still hasn't done it. So there are 2 violations of an order, and there's unresolved questions regarding her substance use, if any. The state believes that the evidence and testimony has shown that she's not regulatable. This board has given her several opportunities to comply with the orders. She's asked for extension. She's gotten them. She hasn't complied. State believes that the factual allegations and the allegations of violations set forth in the amended complaint notice of hearing for both these cases has been established. We would ask the board to find those factual allegations as having been met and find them as findings of fact, and also find that the alleged violations of law have been established and issue those as conclusions of law. Based upon the issues involved here and seemingly Ms. Grant's unwillingness to comply with board orders, the state would recommend that revocation of the license be issued. Thank you.
Thank you, Mr. Hargraves. Ms. Grant, would you like to make a closing argument?
I don't even know what to say. Like I said before, I did not disclose information on my application because there was something that I wasn't aware of or had no real information to disclose. On the second case, I don't got no money. I said multiple times I was homeless. I'm just here for purposes, like work purposes right now. I make $16 an hour. I'm trying to make sure that this lady got somewhere to stay because this is where my kid lives. I don't have no extra money. You want to wait till the 1st of March? I get my taxes. I'll pay you $500. As far as with Texas, I haven't done anything reckless with my license. As far as work, I haven't even touched pharmacy work because I didn't want to mess anything up. I haven't done anything out of pocket. I'm just trying to live my life and possibly keep this going so I could better what's going on. I had a setback trying to help some other people and I got caught up. And all I'm asking is for you not to hold that against me.
Thank you,
That's
Ms.
it.
Grant. Does the state wish to make a brief rebuttal?
No, thank you.
Okay, the board can now begin with general discussion or entertain motions to make findings of fact, conclusions of law, and a final order. The board will now discuss whether the state has proven these allegations, or do you have any questions? Is there a motion to adopt the factual allegations and the alleged violations from the complaint and notice of hearings as findings of fact and conclusions of law?
I'll
So
make
moved.
okay. I'll second.
All right, so that was moved by Dr. Davis, second by Dr. Lehan. All in favor, please say aye.
Aye.
Any opposed? The state has recommended revocation.
I move that we accept the state's recommendation.
Second.
Dr. Gandhi, do we need a roll call? All right.
Who was the second? I'm sorry. Mr. Dank, thank you. Mr. Braswell?
Aye.
Mr. Thorwald?
Aye.
Ms. Nair?
Aye.
Ms. Davis?
Aye.
Ms. Walmsley's recused. Ms. Lehan?
Aye.
Mr. Dang?
Aye.
Mr. Al Nassif?
Aye.
Mr. Anderson?
Aye.
Ayes have it with one recusal, Mr. Chair.
Thank you, Dr. Gandhi. Ms. Grant, thank you. This concludes the proceedings. The board's decision will be reduced to a written order, and thank you for attending today. Welcome back, Ms. Walmsley. All right, we will
Tell
take
me what that mean. I'm
back at
sorry.
15.
Ms. Grant, the board office will be in communication with you.
All right, welcome back, everybody. Let's go ahead and get started. Let's move to item 30C. We had a request due to flight. This is Apostrophe Pharmacy. It's Max. Oh yes, Max is coming. If you guys could both introduce yourselves, please.
Good morning, Madam Chair, board members. Susan Trujillo from Corals and Brady, counsel for Apostrophe.
Kamal
Go ahead.
Saliba, pharmacist in charge for Apostrophe.
Good morning, board members. Max Jacobson, compliance officer with the Arizona Board of Pharmacy.
For the record, I have worked with Kamal before in the past when he worked for Walgreens. It won't impact my decision making, but I'm happy to step aside if you wish me to.
No, we're comfortable with that. Thank you.
Would somebody like to tell us just briefly about the deviation request?
Sure, I'm happy to provide that background. Apostrophe Pharmacy was before the board last year at about this time to request permission to extend its pharmacy operations to a building less than 100 yards away from the pharmacy. The waiver allowed the pharmacy to accommodate its expanding workload while negotiating the lease for a new building and constructing a new sterile compounding space. The process is well underway, and we're here to ask for an additional year to finish the construction. Now I'm going to turn it over to Kamal to provide some additional details.
Sure. Arizona Board of Pharmacy members, again, my name is Kamal Saliba, and I'm very grateful for the opportunity to speak with you today. So I joined Apostrophe Pharmacy as the pharmacist in charge in September of 2024, and I'm here to respectfully request an extension of our waiver, which was approved by the board last year, to allow us to extend our permitted pharmacy space into a non-contiguous building, which is less than 100 yards from our pharmacy. I can attest that this operation has not impacted our ability to remain in full compliance with all laws and regulations, nor has it affected the quality of our services. Instead, it has allowed our staff enough space to continue to operate safely and prioritize quality and patient safety while we looked for and built out a new pharmacy. A pharmacist is present at the second building at all times, and the building has secured entrances and exits. In addition, the security services for our existing building extend to this building as well. I would like to assure the board that we have identified a larger building to accommodate our operations, and we signed the lease. Because this new location will engage in sterile compounding, it took time to find a location that was large enough and could probably be built out and could be properly built out to accommodate our specific needs. As of this date, we are on track to make the move by the end of the year. So we respectfully request an extension of the current waiver to allow us to continue to use the second building until the new pharmacy is complete. Thank you for your time and consideration.
Thank you, Mr. Saliba. Mr. Jacobson, I believe you have no concerns.
That's correct. I did conduct a routine compliance inspection late last year. I reviewed Apostrophe Pharmacy's security policies and procedures around this deviation and have no compliance concerns regarding the deviation request.
And if I may, Madam Chair, just one more point to add. Apostrophe Pharmacy submitted a change of ownership that's currently under review. So we would just ask that the board consider extending this waiver to the new permit once approved. So this can be a seamless change of ownership and a seamless transfer of that waiver over to the new permit.
That's not on this agenda, is it?
It's not. And in the past, we have required new ownership to reappear to address deviation requests.
Any questions or discussion?
Question, is that sufficient time by the end of the year? Or is there a chance that it may take longer than that?
As we stand today, we expect to make the move by the end of the year. Unpredictable circumstances could cause delays if there are delays in materials, for example, or anything that causes to delay the build out of the building. However, our goal is to make that move by end of year, and we're on track as of this moment.
I ask that question because sometimes it's quite often things are delayed. So it might be better if we do grant this to grant it for a little longer, so they wouldn't have to be back before us if they didn't make that schedule.
What time frame are you suggesting?
A year.
So give 2 total years?
Yeah, a year. Then take them back into February of 2006. So it'd give them an extra couple of months.
I'm good with that.
And so, I'm sorry, just to clarify on the change of ownership piece, because I just want to ensure that that there's not an issue with when the change of ownership occurs, this current waiver timing out so that all of a sudden they can't use that second building while we're waiting for that new permit to be approved. They are looking to close, on or about the April board meeting. So, if it's possible, then that we could have that, have to come back and ask for that new waiver at the same time that the new application is before the board. That way we can make sure that this is seamless. I just want to make sure that
The change of ownership is currently in process.
the board has the application. It's scheduled to close. We're setting it up to close on the day of the board meeting or on or about the board meeting in April, so that the new permit will issue on the date of closing, so that we can then send that to California, so that California will then issue its permit on that same day, so that all of this continues to work. So I just want to be sensitive to the timing here and make sure that we're thinking through this so that they don't have to stop operating in that second building while this is happening. So I just wanted to be clear that this is kind of what we had thought through, is having the new waiver request, and if we need to appear before the board for that, and the new permit before the board in April.
Can we have board staff issue a temporary waiver extension if, in just case things go awry with the closing, and until they're able to appear? Is that possible? Because I can understand those logistical challenges for sure.
I
Not trying
appreciate
to
that.
complicate it. for you.
Appreciate that. And it will be the same operating entity. There's just a new ultimate parent that's coming in. And so, this is the same operating entity throughout.
Any concern, staff?
You just go ahead and delegate to staff in the event that another temporary extension is necessary, that they would have the authority to do that, assuming there are no concerns.
Okay, so do I have a motion?
I'll make a motion to extend the deviation request for another year and delegate to staff the ability to issue temporary extension on that if required.
Second.
A motion and a second. All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Thank you for being present.
Great, thank you.
Thank you.
Let's go back to tab 12. 12J. This is complaint number 24-0614. Chris Keyote. If you could please sit down and introduce yourself.
Good morning. My name is Chris Keyote. I am a certified pharmacy technician in the inpatient pharmacy at Flagstaff Medical Center.
Thank you. Welcome. Ms. Brown, if you could give us a brief summary.
Chenica Brown, Executive Assistant to the Deputy Director. Chris Keyote was issued a pharmacy technician license on January 6th, 2011. It expires on October 31st, 2026. His license is currently open. On October 9th, 2024, Mr. Keyote applied for renewal of his license and disclosed that he was arrested on January 8th, 2023 for misdemeanor trespass, 3rd degree. He provided a narrative of events that led to his arrest, court documents, and a letter from his supervisor. Of note, according to his narrative, the documentation he provided, and information on public access, he was not charged. However, the information detailed in Mr. Keyote's written explanation raised concerns about his ability to safely practice as a pharmacy technician. Board staff contacted Mr. Keyote for further information related to the incident and requested a letter from his current provider regarding his ability to safely practice. Mr. Keyote's response to staff detailed health information and is included in the board's files for review. Due to the time that had lapsed between the incident and the notification to the board, in combination with no documentation of concerns from his employer, staff renewed Mr. Keyote's license. On October 22nd, 2024, staff requested a copy of the police report from the incident in January 2023. Mr. Keyote provided a copy of the report, and it is included in the board's files for review and consideration. On November 14th, 2024, staff notified Mr. Keyote that a complaint was opened as the police report further raised concerns about his ability to safely practice. Mr. Keyote responded to the complaint and included the contact information for his supervisor and the last 2 performance reviews from his employer. This case is before the board for discussion, consideration, and to determine how to proceed.
Madam Chairman, Madam Chairwoman, you may wish to go into executive session if you have specific questions.
Does anybody wish to go into executive session? I don't know that I have specific questions. Mr. Keyote, do you wish to address the board, or do you want us to go ahead and proceed with questions?
First of all, thank you to the board for allowing me to appear today. I think I was explained in detail as best as I could, all the events and circumstances surrounding my arrest and the events of that day of my arrest. The main thing leading up to the events of that day was my consumption of alcohol, my overconsumption of alcohol. Very shameful event for me. And it was an event that, obviously needed some addressing. I think I made or set myself on the right path following that incident. All the events of that day. Like I said in my formal response, I pretty much refrain from consuming alcohol at all anymore. I have a handful of times over the past couple of years during, social events, limiting myself to no more than one. Haven't had anything to drink in the past 3 months. I just realize it's not beneficial to anyone, myself, my son, our household, for me to engage in that type of activity. The events of that day do raise concerns. I strongly believe all the evidence needed to determine whether or not I am able to perform duties as a pharmacy technician safely are in the 2 years that I have been doing it since. I've shown by my performance and my performance evaluations and my high marks that I am able to do that. So.
Thank you, Mr. Keyote. I mean, I'm personally comfortable. I mean, he's held a license since 2011. You've never had prior charges for anything like this before or since, correct?
Never with any law enforcement, never with any employers, nothing negative, no.
I agree.
In a general sense, I don't want you to go into detail. Are you taking care of your mental health on a consistent basis?
I'm not currently under the care of a mental health provider. I think I get all the guidance I need from my partner, my girlfriend, my son's mother, turning to her for her experience because she has 4 other children besides my son, 3 of them which are still within our household. I don't feel like that's anything that I currently need, so I haven't been under the care of a mental health provider for a while.
I agree with where you're going. It seems to me to be an isolated event, and I'm comfortable with proceeding with a dismissal. I can make that my motion.
I second.
A motion and a second. Any discussion? All those in favor?
Aye.
Any opposed? Hearing none. Thank you for being here.
Thank you, all of you.
Let's go to 12K. Kyle James Sorensen, board case number 24-0561. Is Mr. Sorensen present? He is.
Yes.
Sorry. If the parties could please introduce themselves.
My name is Molly Adrian. I represent Kyle Sorensen, and he is also on the line.
Mr. Sorensen, if you could please unmute yourself and introduce yourself.
Hi, yeah, I'm Kyle Sorensen.
Thank you. Ms. Brown, can you please give us a brief summary?
Certainly. Jenica Brown, Executive Assistant to the Deputy Director. Kyle Sorensen was issued a pharmacy technician license on September 11th, 2012. It will expire on October 31st, 2026. His license is currently open. On October 15th, 2024, board staff received notification from Ironwood Cancer and Research Centers indicating that Mr. Sorensen was terminated on or about September 13th, 2024 for dispensing large amounts of unauthorized samples of Xarelto to a family member. The notification specified that 27 bottles of 10 milligram samples of Xarelto and 27 bottles of 20 milligram samples of Xarelto were dispensed without authorization. Each bottle contained at least 15 pills per bottle. The complaint also alleged that Mr. Sorensen used credentials that did not belong to him. On October 21st, 2024, staff issued a subpoena for records to Ironwood to further obtain information related to the complaint. Staff also sent a notice of complaint to Mr. Sorensen and requested a written response. On November 4th, 2024, staff received a notice of representation for Mr. Sorensen. Staff also received a response from Ironwood on the same day. Ironwood's response included investigation notes and a Xarelto audit. The documents are included in the board's files for review and consideration. Of note, the investigation notes provided by Ironwood addressed the allegations of Mr. Sorensen using credentials that did not belong to him. Ironwood identified that it was not uncommon for pharmacy technicians to leave their profiles and logins open, and that techs were retrained to log off when they leave their workstations. Also contained in the investigation notes is a narrative from an interview with Mr. Sorensen regarding the unauthorized samples. According to the notes, Mr. Sorensen admitted to dispensing the sample drug to his spouse, who is a patient of Ironwood, since the drug was expensive and he and his wife were struggling financially. He indicated that he didn't think it was an issue since they were samples, and he had no ill intentions. Mr. Sorensen was placed on an administrative leave on or about September 13th, 2024, and was ultimately given the option to resign in lieu of termination, which he did. Staff received a response to the complaint from Molly Adrian on behalf of Mr. Sorensen. The response is included in the board's files for review and consideration. The response provides a background for Mr. Sorensen's employment timeline with Ironwood, medical and financial details surrounding Mr. Sorensen and his wife, a detailed explanation of Mr. Sorensen's actions involving the unauthorized dispensation of Xarelto and using credentials that did not belong to him, mitigating factors, and a segment discussing the impact that a disciplinary decision would hold on Mr. Sorensen. Mr. Sorensen asserted that he never intentionally used any of his colleagues' login credentials to hide what he was doing and that he takes accountability for his actions, understands why he should not have done what he did, and will not do anything like it again. Council submitted a supplement to the response on January 13th, 2025, which included certificates of completion for 11.5 hours of continuing education in pharmacy ethics. The supplemental information is included in the board's material for review and consideration. This case is before the board for discussion, consideration, and to determine how to proceed.
Thank you, Ms. Brown. Would you like to provide any commentary, Mr. Sorensen, or your counsel, or would you like us to proceed with questions?
I'll make a brief statement on Mr. Sorensen's behalf, and he's also available for your questions afterwards. Again, my name is Molly Adrian. I represent Mr. Sorensen in relation to this complaint. As exemplified by his written response to the allegations, Mr. Sorensen is an honest and hardworking individual who made a mistake. He takes accountability and has accepted the consequences of losing a job that he was proud of at a company that he hoped to grow with. And he is also taking accountability here today in front of the board and with the PTCB. Just to recap the facts, Mr. Sorensen's wife was diagnosed with a potentially
Molly, will you please, this is Jean Galvin, the board's attorney. Please refrain from disclosing any medical health information on the public record.
Sure. Yeah, I think that's a big part of what happened here. So I guess I'll just say that I hope the board will read the materials and recognize the intent behind what Mr. Sorensen did, that it was not intended to be, he wasn't, diverting drugs for some ill-intended purpose. He and his family at the time were in a precarious financial situation. And so that also contributed to his actions. Based on his experience, at Ironwood, he honestly believed that filling prescriptions with samples was authorized. He had done it in the past, though at the order of a physician or superior, and now recognizes that he didn't have the discretion to do that on his own. As for using other pharmacy techs' credentials, he did inadvertently enter prescriptions under other pharmacy tech login credentials, but was not intentionally hiding anything. As was mentioned, it was common practice for techs to leave their station without logging out, and then someone else would step up and not log in under their own credentials. And he now fully comprehends why that's an issue, and would not do so again. So he understands, that there was a conflict of interest and he shouldn't have done what he did. He's preemptively taken over 10 hours of continuing education geared towards pharmacy ethics. And just to close, as the board discusses the situation, we hope that you'll keep in mind the effect that a disciplinary decision would have on Mr. Sorensen's future. Though it might not in itself impede his ability to work as a pharmacy tech, it would almost certainly cause the PTCB to take action on that certification, which would in turn impact his ability to have an Arizona pharmacy tech license. And then additionally, if Mr. Sorensen were to apply for any other kind of license in the state, such as real estate license, something like that, he would have to disclose a disciplinary decision, which could negatively impact his ability to obtain such a license. We hope that you'll take his sincerity and his honesty into account in your decision. He was truly trying to provide for his family and made an unfortunate and costly mistake. He understands that he was misguided and has learned an important lesson about boundaries in his professional and personal lives. And then notably, he has otherwise had no discipline by this board or any other board or any other negative employment reviews or actions in his history. So with that, we hope that you will consider resolving this with a dismissal or other action short of imposing a disciplinary order.
Thank you. I have a couple questions for Mr. Sorensen. Mr. Sorensen, this Ironwood Cancer and Research Centers, I don't believe that they're licensed as a pharmacy. Were you working under the supervision of a pharmacist, or were you working under a supervision of a physician? I just want to kind of understand what your role was at Ironwood and what you did on a day-to-day basis.
Yeah, so we did have a pharmacist who is employed there, but they're not they're not on location with us. To the best of my knowledge, they're under the medical board and not the pharmacy board. So we didn't have a pharmacist on site.
So what type of things did you do on a day-to-day basis? Explain what your job was.
Sure. So we compounded the chemotherapy IV meds for our cancer patients. So we would get the prescription. We would then pull the medication from our links, and then we would have it checked by a nurse. The nurse would verify the dose, the drug, and then give us the label back to us, and then we would take it from there, and then we would compound the drug, and then another pharmacy tech would check us prior to injecting the medication into the IV bag. Once that was complete, it would go out onto the floor where it would be given to the patient right there on site.
And what was your role with, so this looks like it was an outpatient prescription. So did you, does this physician's office dispense outpatient physician prescriptions? What is your role with the samples and all those kinds of things?
Sure. So it's all outpatient there with the company. We would have samples of all kinds of drugs. And so we had them there on site. And so that wasn't uncommon. We had them, and then we would give them out to whenever a patient needed them or the doctor wanted them. So we always had them with us on site at each location.
So in the case of these medications that you were terminated for taking, they were for a family member, and we won't get into the details of the drugs. But it's my understanding that you processed these under another pharmacy team member's credentials.
Correct. So there were a couple of times when I had pulled them from our links, which is our operating system to be able to pull meds. And like stated before, it's not uncommon. You would walk away and someone else would log in, and then you'd walk back and you wouldn't realize that the tech next to you had logged in. So that wasn't uncommon. That happened often. So again, it was never intentional. I never purposely intended to do that. I just didn't realize it when I went to go pull it. I didn't see that so-and-so logged in as opposed to me still being logged in. So that was something that was commonplace there.
But to to dispense these sample medications to a patient,
Mhm.
you have to have a physician's order to do that.
Correct.
Did you have an order in this particular case?
Well, my wife did. I don't know what I'm allowed to say, but she was prescribed the medication there from a physician there.
But did you have an order to provide the samples?
No, I did not. No, I did not.
You acted on your own will to do that.
Yes. Yes.
Okay, thank you.
Yep.
And just to clarify, your job title there is pharmacy technician?
Correct.
Okay. That was all for now.
Yeah, we always had this discussion like doctor's offices hire pharmacy tech or pharmacists, for example, using their knowledge, not their license, right? Because we give license to work in the pharmacy or whatever board of pharmacy regulates, correct? In his case, I believe he was working as using his knowledge as a pharmacy tech, not license, right? Because we don't regulate this kind of practice, doctor's offices. So
Clearly, the doctor's office thinks he's a pharmacy technician and reported him to us
correct.
that he was terminated for this inappropriate activity. I mean,
Correct.
I have a concern about a lot of things that were happening there, and I think potentially I would like to forward this to the medical
medical
board for investigation. Based on some of the commentary that he made, I mean, there's nothing there from our perspective that we can necessarily do about it. We've discussed that at nauseum, but I still think that obviously his actions were improper.
I mean, that's exactly, I have the same concern about how they practice there. To me, it sounds like they're acting like pharmacy, like hiring pharmacy technician. I know some physician allowed, I cannot speak on the other board, behalf of other board, but I know they do some sort of compounding. But the way he described the workflow to me is more than like pharmacy, and he said they take it to the floor. I just got a little bit confused. I definitely need to refer this case to medical board to evaluate the workflow there.
Ms. Galvin, Mr. Hargraves, since this was reported to us and he says he was working as a pharmacy technician, is this within our jurisdiction? Since it didn't occur in a pharmacy?
I would believe that it is within your jurisdiction. I don't think you can just remove your pharmacist hat or your technician hat and engage in those types of activities and expect to be excused from any requirement that you act in a professional manner or comply with statutes and rules.
Yeah, thank you very much. So I believe this is unprofessional like conduct that it took place outside of pharmacy. So I believe he's done 11 hours, my understanding, of ethical pharmacy ethics. Is that right? You've done some CEs?
11.5.
11.5.
Yes.
So yeah.
I think one of the concerns, Madam Chair, is pharmacy technicians work under the supervision of a pharmacist. Even an admixture technician, I think that's the discussion we had a while ago. Many companies move to that title. But in this case, it seems like he was working independently without supervision from a physician even. And that seems to be a concern. Now, I don't know if there's a confusion that when they have a pharmacy tech license, these physicians think that they can work independently. I'm not sure. But I know that's something we were tackling some time ago. And I had thought we'd addressed it, but apparently it's still happening.
So considering the hours he already did, I move to advisory letter for him.
This was very similar to a case we had yesterday. And I, at the time, raised that we should probably move to a disciplinary action, given the repeated nature of the offenses.
That happened what's happened yesterday, it was inside the pharmacy, a pharmacist. This is a pharmacy tech working with no supervision. And I don't know how they handle the samples there. I mean, to be honest with you, like.
Well, he just stated that it needed an order and he didn't have one. So I feel like they were also working outside of their scope.
Mm-hmm.
And in the past, when, let's say, a technician's used a pharmacist credentials to okay a prescription and that was working outside of their scope, I think we've done probation and had other disciplinary action.
Mm-hmm.
I can certainly understand if she had a prescription for the medication and the samples were free, why it might be, one might lead to the other. But still, I think that it's inappropriate to process prescriptions under someone else's credentials, even if it was yeah, exactly.
To me, there's two different things. One, the physical facility itself and how they're handling this whole process, and what he did. And I think we have to deal with what he's done, but also whether we can do anything or we have to refer to the other board. It seems like the way that Ironwood is handling this is inappropriate in the first place, the whole process.
Another concern I have though is we're not looking at 1 or 2 bottles of samples. We're looking at 50. And so even if in the beginning it was taken as the fact of, but we give samples to people who need or who are starting or whatnot, I think that it persisted way beyond that.
So I had a motion. Did I have a second?
Add something for discussion.
There was no discussion. No second. So motion fails.
Go with advisory letter
Advisory
because
letter.
I believe we don't know about the workflow there. It's not a pharmacy. There's no rules there.
But if he was working as a technician, he was working outside of his scope.
Mm-hmm.
He said his title was pharmacy technician, and he does have a pharmacy technician license.
But this, yeah, that's always we discussed that previously. So this is very gray area, right? It is very just like when PBM they hire technicians, they hire pharmacists.
I think this is very clear that what he was doing was the work of a technician, though, comparatively to that one that was like the phone call thing and prior authorization. Like this is dispensing, this is compounding.
Yeah, I agree with this part, but that's why also we refer to medical board. So my motion failed, right? So,
Do I have an alternative thought?
We could offer a consent agreement to include a letter of reprimand
Mm-hmm.
to be signed within 30 days or moved to hearing.
Is that a motion?
Sure, I'll make.
I'll
my
second
motion.
that.
A motion and a second. Any discussion?
May I jump in?
We're in discussion now.
Would we do anything with regard to Ironwood?
I think referral would be appropriate.
What about advisory letter to Ironwood?
We don't have a license for them.
Oh, that's true.
Can we make a referral to the other board?
Mm-hmm.
Yes, we could.
It seems also like that this has been a problem in the past and that there should be additional discussions with the other boards to better coordinate how these things are handled, or even legislation that clarifies these kinds of things, that takes these ambiguities away.
so your motion based on what? The samples part? Like, okay, just to make sure. Yeah.
The unprofessional conduct.
Any further discussion? Do we wish to hear from Mr. Sorensen's attorney? Anybody?
Madam Chair, just one thought, and
Yes.
this is for Ms. Galvin and Mr. Hargraves. Since there was technically no supervision, can we assume that this facility is acting like a pharmacy and issue a cease and desist?
I'm not sure we have enough information to issue a cease and desist.
Just from the testimony, and then they can reply. Obviously, we can't solicit a response, but I'm sure in their best interest they would.
I think that is something that we can discuss, and that's a possibility.
It seems to me like that we should do something like that as well.
We're still good on the motion for Mr. Sorensen. And then we can decide what we want to do with Ironwood, if anything. All right, Dr. Grandi.
Mr. Braswell.
Aye.
Mr. Thorwald.
Aye.
Ms. Nair.
Aye.
Ms. Davis.
Aye.
Ms. Walmsley.
Aye.
Ms. Lehan.
Aye.
Mr. Dang.
Aye.
Mr. Al Nassif.
Nay.
And Mr. Anderson.
Aye.
Ayes have it with 1 nay, Madam Chair.
Thank you. Now, with regards to Ironwood, is there anything we want to discuss further there? I would be in favor of at least referring this to the medical board to look into further.
I would also be in favor of that, but I also think we should issue it the cease and desist and get their response. I think at the minimum that would at least bring this to their attention and potentially help with the other boards if they take any action.
Let's play devil's advocate here. So is it a cease and desist from all pharmacy activities? Because this place is probably making IV admixtures for chemotherapy and things like that, and we could stop patients' therapy if we issue a cease and desist. I just want to make sure we're not going to be further harming Arizonans.
So point of discussion is a prescriber, medical doctor has the authority to compound. And I'm assuming they have the authority to delegate compounding, but that doesn't take their supervision away. And from this testimony, it looks like they're not supervising that activity. So maybe that will prompt them to supervise and make sure those products are made safely and are safe to administer. I don't know.
It seems like that's also a danger if if it's not handled properly or done well, then that's also a potential danger to the public. So it goes both ways in my view.
There was some discussion about, we don't know. Prior to jumping to a cease and desist where they may have to cease what they're doing out of caution and potentially impacting patient care, you do have the option to refer this to the medical board. You can also informally send a communication raising the issue and asking them to give you more information about the practice before jumping to a cease and desist. So that way, maybe, like you said, don't have enough information, maybe try to solicit that information on the front end before jumping to a cease and desist.
That sounds good.
I think that would be smart.
Yeah.
And Madam Chair, I'd like to limit it not to just the medical board, but any appropriate agency.
That's fair.
Just out of curiosity, does the medical board employ compliance officers for any sort of? Okay. Thank you.
So you mean like also nursing board, right?
Possibly, or
Nursing board.
DHS. And I think
Yeah.
we've already tried to do that in this situation. And we kind of got bounced around, but I think with this testimony, it may move it forward a little bit.
Not in this situation, but in similar.
Similar, yeah.
I agree.
Do you need a motion?
Yeah, we would prefer a motion.
Okay, do I have a motion?
I'll make a motion to refer this to the appropriate boards for additional information.
Perhaps to refer to other relevant agencies for investigation and authorize the executive director to reach out by letter to Ironwood to obtain more information.
I amend my motion to include that.
I second.
Any further discussion? All those in favor? Aye. Any opposed? Hearing none, motion carries. Thank you for your attendance. Okay, that brings us to noon. We don't have that much left on the agenda. How does everybody feel?
Keep going.
Keep going?
Keep going.
Keep going. Okay. Let's go to item 12L and 22D, which is Richard Carroll and St. Luke's Behavioral Health Center.
Hello, and I'm sorry, that's Rochelle Carroll, not Richard Carroll.
I apologize for that. If you could please introduce yourself for the record.
Yes, I'm Rochelle Carroll, the Director of Pharmacy for St. Luke's Behavioral Health Center.
Thank you. And I believe we have Mr. Wagner on remotely today.
Yes, I'm here. Thank you.
Mr. Wagner, can you give us a brief summary? I believe we have a complaint and then also a renewal application for the pharmacy permit.
Yes, so in September of 2024, the Board of Pharmacy became aware that the healthcare institution license for St. Luke's Behavioral Health Hospital was summarily suspended on August 13th of 2024. One violation cited in the suspension order was a failure to maintain the facility HVAC system, resulting in elevated temperatures in patient care areas above the 70 to 75 degree Fahrenheit requirement. On August 9th, the facility notified the Department of Health Services that the facility HVAC system had failed throughout the hospital. A DHS officer arrived at approximately 10 a.m. to perform an environmental inspection. The officer recorded the temperature of a patient care area as 87 degrees Fahrenheit. The facility began to transfer patients to other facilities, with all patients transferred by approximately 5:30 a.m. on August 10th, 2024. The PIC stated that the failure of the air conditioning units affected the operational side of the inpatient section of the hospital. The area of the hospital that housed the pharmacy and the overnight Pyxis unit was on a different cooling system and was not affected by the equipment failure in the patient care areas. After the patients were evacuated, the medications in the individual units, including code carts and emergency boxes, were quarantined in the respective units. Once the units reached a safe temperature, the medications were removed and segregated for destruction. The renewal application for the pharmacy indicated that an interim management agreement had been agreed to by the bankruptcy court to provide College Health the opportunity to preserve the hospital's license while it submits a change of ownership to DHS.
Thank you, Mr. Wagner. Ms. Carroll, would you like to make some opening statements before we proceed with questions?
No, not at this time.
Okay, thank you. Board members, questions?
Mr. Wagner, I saw in the evidence that it seemed like the Pyxis reports demonstrated that the meds were removed from the ADMs and brought back to the main pharmacy. But were there any reverse distribution records that you saw that demonstrated that they were actually destroyed and sent to the reverse distributor? And also any purchase records to reflect new purchases of those drugs that were destroyed?
Not at the time I had visited the hospital. I did speak with the PIC recently. The medications are still segregated for destruction. They had difficulty scheduling the destruction due to the financial difficulties of the ownership and the bankruptcy court. So Ms. Carroll may be able to speak more to that.
So Ms. Carroll, as follow-up, do you have a reverse distributor contracted to pick up?
So we have Stericycle contracted now to come pick up and remove them. Excuse me, I'm sorry. However, up to this point, we had not had a contract with Stericycle because of the issues with Steward. So the meds remained segregated with our outdated medications so that they were not utilized, waiting for the contract to be made with College Healthcare so that Stericycle could come in and remove them and destroy them.
But to my knowledge, Stericycle is not a reverse distributor.
So
They don't-
Inmar was our reverse distributor with Steward. So we have to set up a new reverse distributor also. But usually Inmar only took like the controlled substances. And
No.
Stericycle took our red bin waste.
Inmar takes everything, both control and non-controls.
Okay, well, I can set up, either Inmar or whatever reverse distributor College Health will contract with to have them take that, but they are still segregated until we could obtain a new contract, because the companies that were contracted with Steward were unwilling to come out due to the balance owed to the company. So we've had to obtain new contracts for everything.
But none of these medications were dispensed to patients.
The medications were dispensed to the patients during the time that the evacuation was occurring. And then once everybody was out, everything was segregated for destruction.
Was there any evidence that the medication was stored outside of the appropriate temperatures?
The med rooms were hotter than the appropriate temperatures.
For how long?
For the duration of the evacuation.
Did you do any sort of review for temperature excursions of each meds that these patients received?
I did do a review and found multiple studies stating that the medications could safely be outside of the normal window for a period of time. And I also weighed the fact that the staff was unable to run to the pharmacy for each dose while they were evacuating the patient. So risk versus benefit, the alternative would be not supplying medications to the patients at all.
To what I'm reading, there was no notification to the board. We just found this out through other channels. Can you speak to that?
I apologize. When all of this was going on, I honestly did not think to immediately notify the board of everything. It was literally an emergency and trying to evacuate the patients and get everyone out safely. And I honestly did not cross my mind, and it should have. I apologize.
Miss Carroll, how long was the duration of the evacuation?
I would have to pull up documents. It would have been August. Hold on.
Madam President, if I may, the table on the second page of the summary shows the temperatures in the patient care areas from the DHS report and the number of dispenses from those Pyxis units. However, I don't have temperatures for the med rooms themselves. So that's specifically in the patient care area.
But it was approximately 3 days.
Yes.
So Ms. Carroll, you said you identified drugs with temperature excursions that were outside of the appropriate range. Did you tag those or patients that may have been administered those therapies to have the medical staff review the patient for any untoward side effects or any sort of results
The-
from potentially receiving medications outside of the approved temperature range?
I mean, the medical staff was aware of what was going on as the patients were being evacuated, and the patients were monitored until they left our care and went to another facility.
Ms. Carroll, is the bankruptcy still underway through the courts?
That is correct. College Health is currently managing the facility, not Steward, and they are in the process of a change of ownership.
Ms. Galvin, Mr. Hargraves, I mean, obviously there's bankruptcy laws that we're not familiar with. Are we even able to address anything with the permit holder while they're in bankruptcy?
I don't know the specifics of what they have filed, whether it's 713. I don't know. Generally, if there is a bankruptcy, you cannot impose a monetary fine against the entity, but something like an advisory letter or decree of censure that doesn't spark a financial remedy, you can do that. But I would need more information about exactly what chapter and where they are in the process.
But as far as the individual licenses go, they're not protected under the bankruptcy.
Correct. It's just the entity would be the permit holder.
Thank you.
Is this facility open?
She indicated it's being operated by which pharmacy now? I'm sorry, Ms.
So
Carroll.
College Healthcare is managing it. The facility is not completely open. Only one unit is open at this time.
So you're serving patients.
Yes.
I see this as an extreme kind of emergency situation. And I also recognize that when we're looking at a behavioral health center, when we're in those circumstances of high stress and they're having to evacuate people, those with mental health concerns would likely really be in detriment if they did not have their medicines. So while it is absolutely not an ideal situation, I also see it as an emergency situation that they were trying their best to work through at the same time.
I agree, but we haven't heard from them since then either. So maybe in the emergent time period, there was a reason why you didn't think to call, but afterwards, there was still no call. So my thought is a $250 penalty that's disciplinary for failure to report. And
I think that's where it kind of gets tricky as far as, is that acceptable?
Generally, a civil penalty against the permit holder who is in bankruptcy.
no, I was thinking to the PIC,
To the PIC.
to Miss Carroll.
Okay, that would be appropriate. What provision, what is she required to report?
I think there's a couple of issues that Mr. Wagner brought to attention. Some areas of where the medications were kept were not monitored as far as temperatures go. That's an issue. This may have been identified sooner than later.
Okay.
I don't know. But operating under unsafe conditions would be, and not notifying the board would somehow be
And
unprofessional
dispensing
conduct, I would
medication
think.
that you've identified may not be safe.
Yeah, it's potential that having this excursion, there's without having tested the product, we can't exactly determine it, but having it out of temperature range could be an adulterated product that was administered.
Say your motion.
Yeah, I was headed towards $250 disciplinary fine for Miss Carroll and a letter of censure to St. Luke's Behavioral Health Center.
Second.
Any further discussion? Dr. Gandhi?
Thank you, Madam Chair. Mr. Braswell?
Aye.
Mr. Thorwald?
Aye.
Ms. Nair?
Aye.
Ms. Davis?
Aye.
Ms. Walmsley?
Nay.
Ms. Lehan?
Nay.
Mr. Dang?
Aye.
Mr. Al Nassif?
Nay.
Mr. Anderson?
Aye.
6 ayes, 3 nays, Madam Chair.
Thank you, Dr. Gandhi. Thank you for being present. Let's,
Madam Chair, does that also include 22D?
oh yes, we need to take care of the permit. Thank you for reminding me. Do I have a motion with regards to the renewal? Probably appropriate to approve the license upon signing of the consent agreement.
I'll make that my motion.
Well, the consent agreement would be to the individual.
There
Looks
was-
like was it
There was a
Letter
letter
of
censure to the,
was it advisory letter or a letter of reprimand?
No,
Letter of censure.
Decree of censure, okay.
do they have to sign that?
Yes.
So renew the license upon signature of the decree of censure.
Yes.
Second.
Okay, that's my motion and I have a second. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. Let's go to 22E, Navajo Health Foundation Sage Memorial Hospital.
That's Mr. Wagner as well.
Thank you. Welcome.
Thank you,
Yes,
Madam
please.
President. Sage Memorial Hospital, located on the Navajo Reservation land, was issued a permit back in July of 1969. As the board may recall, representatives from Sage Memorial Hospital appeared at the board meeting on April 18, 2024 to request a deviation from emergency services dispensing requirements to allow the pharmacy to prepare prepackaged drugs for dispensing by a nurse practitioner. The board offered alternatives to the request. Ultimately, Sage Memorial Hospital requested to close their permit on April 30th, 2024. The permit was officially closed on May 1st, 2024. On August 20th, 2024, Sage Memorial Hospital requested to reinstate the permit due to difficulties in drug procurement. Following discussions with board staff, the permit was reopened on October 31st, 2024. And the expiration date was extended to February 14th, 2025 to give Sage Memorial Hospital the opportunity to appear before the board regarding the reinstatement of the permit. Additionally, the hospital relocated into a new facility that was inspected by me on November 5th, 2024. The new facility is located at the same address on Navajo Reservation land.
Thank you, Mr. Wagner. Can you please introduce yourself and if you'd like
yes,
to address the board?
Yes, my name is Damiette White. I'm the pharmacist in charge at Sage Memorial Hospital.
Thank you, Mr. White. Do you have any preliminary remarks you'd like to make or should we proceed with questions?
You could proceed with the
Okay.
questions.
So you appeared before us before and you decided that you did need a license and you relinquished your license to us. What's changed? How are your operations different now than they were before?
Well, nothing really changed. The only thing that changed was that the nursing staffs were unable to take the pharmacy medication to go distribute in the communities.
Prior to my becoming pharmacist in charge, what the practice, based on my investigation when I became a pharmacist in charge, was that the nursing staff at Sage Memorial Hospital, including the dental department, we are coming into the pharmacy, inpatient pharmacy, collecting the inpatient pharmacy medications that were intended for the ED, because there are rules under the regulations under the administrative code that allows the ED providers to do emergency dispensing. So they were using those medications, going into the community and distributing those medications in the community. So when I became pharmacist in charge, I discovered that practice was going on. And also another practice that was also going on was after the distribution of those medications, the inpatient, so the permit, the pharmacy operates both inpatient and outpatient pharmacy under the permit. So what was happening is that they would, the medications were retrieved under the inpatient pharmacy side of it. The medications were then distributed in the community. And then after the distribution, the nurses would then go around, and then the administration would then mandate the outpatient pharmacists to verify the medication that they did not distribute. So when I became PIC, I stopped all those practices. And so that triggered a lot of processes, including we coming down here to request a deviation. So what changed, just to summarize, was that up till now, they are not able to retrieve the medications to go distribute in the communities.
So I believe when you were here before, our concern was that the medications were being taken from the hospital pharmacy and then taken out in like a van that was going to go to different parts of the Navajo Nation. And please correct me if I'm wrong. And distributed, and then those medications were going to come back to the hospital at the end of the day or at some point in time. And that was our concern, is that wasn't a permissible activity since it wasn't a physical location.
Yes.
Is that what you're still planning to do?
Well, so when we after we came here, soon after we came here, there were a lot of meetings and series of events happened, and the board, including the executive management, deliberated extensively on the next step forward. And so they wanted to maintain the status quo at that time. They wanted to continue to have the permit rescinded so that they could be able to continue to distribute the medication. But then what happened was we were having difficulties with having certain essential medications. And so at some point, the executive management, including the board, was not compelled, but had no choice but to request that I put in a request to reinstate the application. The medications before that time were going out. They would come pick up the medications. The medications would go out in the vans. I don't know what was happening with the medications under all kinds of temperatures and under all kinds of conditions. Being exposed to all kinds of, anybody pretty much. And then the medications would then be brought back to the pharmacy. So it was, I think it was an unwholesome practice, at least the way I saw it at that time. That was why I stopped it. But when we reinstated the permit, then I had no choice but to put a stop to it as well, again, immediately.
So what are you doing now?
Now they are not able to retrieve the medications. So the medications, I don't allow them to retrieve any pharmacy medications for the purpose of distribution by anybody other than through the pharmacy by a licensed pharmacist.
So are you stopping the mobile practice? You're not going to do the mobile practice?
Well, I don't have the ability to stop the mobile practice, but I have the ability to prevent them from retrieving our pharmacy medications for the purpose of distribution in the communities, except through the pharmacy by a licensed pharmacist. So the practice is still on. They still go out. The nurses still go out with the mobile van to the community, but they are not able to retrieve our medications for the purpose of distribution in the community.
So just for clarity, are the nurses bringing medications with them when they're meeting with these patients?
since we reinstated the permit, that process stopped. I stopped it. So they are not able to retrieve our medication from the pharmacy for the purpose of distribution to anybody.
So how do the patients obtain their medication?
So we have a pharmacy permit through the board, and for the period the permit is active, the pharmacy, I make sure that the pharmacy operates under the administrative code of the Arizona State Board of Pharmacy. So that means the medications are only dispensed. We have inpatient and outpatient pharmacy. So for the outpatient pharmacy, the medications are dispensed through the outpatient pharmacy. From scripts coming from prescription medication, prescription orders coming from a licensed provider, which could be within or outside Sage Memorial Hospital.
So, Mr. Wagner, can you explain to us the deviation? I'm very confused, and maybe I'm the only one that's here.
I'm sorry, the deviation?
Or this is just the renewal. There isn't a deviation request?
There's a deviation. I read there's a deviation request.
Well,
And what's a pick point? How does that come into this picture?
Well,
of
so
the
when
dispensing system?
So when we reinstated the permit on the 31st of October 2024, and then I had to prevent non-pharmacists from dispensing medications. Then the board and the executive management started looking into other alternatives, including PickPoint. PickPoint is a machine that is intended to be installed in the ED as well as in a place called Greasewood. Sage Memorial Hospital does operate a clinic in Greasewood, and the clinic is called Greasewood Clinic. That facility.
Would that require a kiosk?
So to answer your first question, Madam Chair, and I'll get to yours as well, Ms. Nair, is the deviation request was from last April when we denied it. So there is no deviation on the table. We had a discussion with Sage Memorial leadership to talk about kiosk opportunity or remote dispensing site pharmacies. So they have all the tools available to provide this service. But it seems like now you're doing patient-specific prescriptions, and those are being delivered outside.
But they're
of the
being
pharmacy.
filled in the pharmacy and delivered.
And then delivered that are patient, and that's okay within our rules.
Right.
If they want to extend that arm, obviously they have that ability through remote dispensing site pharmacies, kiosks, and so forth. And those options were explained to them when we had the call several months ago.
So are we confident that they are operating lawfully at this point?
Confident as we can be. You know, they're obviously out of our jurisdiction. We will inspect them periodically. And we'll, since this is on our radar, this is something we will look for. But
And the kiosk is not currently being used. It's just something that's in discussion.
Well, as of this moment, as of last, I left there, I think 6 p.m. As of 6 p.m., based on the information I gathered, Greasewood is under construction for the purpose of installing the kiosk, which is the big point.
So just want to make sure, well, I understood from you that you can prevent getting medication back to the pharmacy, right? That what you said. The nurse will not give you the medication back at the end of the day, right?
So prior to when I became the pharmacist in charge.
No, now what you said.
Oh,
you
yes.
said like,
Now they are not able to retrieve our
Okay.
medications from the pharmacy.
So
Therefore,
don't retrieve.
there is nothing to return.
Okay, so you give nursing staff medication not labeled, not specific to patient, right? Not patient specific.
No. So as of
said, that's gonna make sure to hear from him. That's why.
yeah. So under the board rules, under the administrative code, the emergency department in the hospital, the providers in the emergency department in the hospital can do emergency dispensing.
Okay.
So we have a pre-labeled medications for that purpose. What was happening was that the nurses, including the dental department, some other few nurses in the hospital, we are coming into the inpatient pharmacy to retrieve those medications for the purpose of taking those medications into the community for distribution to patients. So when I stopped that, then, as I said, it triggered a lot of processes. We ended up coming here, and I told them if I was to continue, then I wouldn't let them. I wouldn't let that practice to occur. So we all came here. We sought a deviation, which was not approved. Now, the board and the executive management decided to maintain the status quo. In other words, to have the permit continue to be rescinded at that point. That was from I believe from May 1st. So from May 1st up until October 31st, 2024, the permit was rescinded. So during that period, we were not under the Arizona State Board of Pharmacy. So during that period, the nurses were able to come in, take those medications, go out to the community and distribute to patients. Now, prior to October 31st, when I was instructed to have the permit reinstated, and I put in the application, the request to have the permit reinstated, the permit then became active on October 31st. So immediately it became active, then I stopped the process again. So from that October 31st, 2024 up until now, the nurses are not able to come into the pharmacy to retrieve those medications for the purpose of distribution in the community to patients. So I believe I believe the executive, the board of directors and the executive management of Sage Memorial Hospital believe that impedes the ability to provide service to some classes of their patient population. And so immediately the permit was, no sooner than the permit was reinstated, they started deliberating on what next to do. Among the deliberations was to have it rescinded again. And I believe they went back and forth, including with their attorneys and so forth. But as of yesterday, when I left Sage, the direction I was provided with was to request to have the permit renewed. But a few minutes ago, I had another update that the board of directors of Sage Memorial Hospital deliberated today, and have decided to have the permit. They have decided that they would not renew the pharmacy permit.
So are you asking to withdraw this request?
Not to withdraw the request, but the permit will not be renewed after it expires tomorrow.
Okay, so you withdraw your application to renew, right? You're withdrawing the application, so you don't need to renew it.
Yeah. So based on that, I will not renew. We will not renew the permit. We'll just let it expire.
Madam Chair, if I can kind of summarize a little bit here.
Please.
From the time we reactivated your permit to tomorrow, we'll say.
That's correct.
You have not conducted activity to allow people to come into your pharmacy, take the meds and distribute it. So you've been in compliant with the Arizona statutes and rules, correct?
It's not been easy because it's been it's not been easy.
Okay.
I think I've probably notified the board a few times with.
But after today, you're stating that your board has decided that you don't need this permit anymore.
Yeah, they said since I'm not allowing them to retrieve those medications for the purpose of distribution in the community, then they have instructed me not to renew the permit and just have it elapse.
So I think we have two options from the board's perspective: is deny your renewal, which is a discipline, or is it customary to offer them to withdraw the renewal application?
I think in this circumstance, it would be appropriate to allow them to withdraw.
So that is your decision if you want to withdraw, or if you want us to move forward with the discussion and potentially deny.
I'll put in the request
to withdraw.
To withdraw.
So you're requesting to withdraw the application at this point, the renewal.
I have not sent in a renewal application, but
We have the renewal application in front of us.
Oh, you do?
This is what we're discussing.
That's what we're
today.
discussing right now.
I believe it's a reinstatement.
Reinstate,
not
sorry,
renewal.
reinstatement application is before us.
Oh,
Reinstated in October.
It was done as a,
It's done as a renewal.
okay,
was that the one that came in October 2024?
yes.
Okay, okay. Yes. So I'll put in an application to rescind the application.
Well, we can just do it right now.
We can do
on
that
the
right now
record.
verbally.
I request it be done right now.
Okay, so do I have a motion to allow them to
Withdraw,
grant the request to
withdraw.
withdraw
I'll make
their
a motion
application?
to grant the request to withdraw.
Second.
I have a motion and a second. All those in favor?
Aye.
Thank you for being here today.
Just point of discussion, it would have been nice if we started off with that. But that's just my feeling.
Very good, thank you. Let's go to 22F. Jennifer Miller.
Hi, good afternoon. I'm Jennifer Miller. And
Hello, Miss Miller. If you could tell us why you're here today.
sure. And I just want to thank you for allowing me the opportunity to sit in front of you and have this discussion. I'm sitting in front of you asking to be reinstated for my pharmacist license. I'll take full responsibility that it wasn't renewed in October of 2022, which I thought that I had renewed it. There were some communication issues that I didn't follow up on. And then so when I went to renew in October of 2024 is when I realized that the license has lapsed. So I am asking to be reinstated. I have paid the fees and to move forward. And I know that there was a question on where I work. And I think that that was a little bit convoluted going back and forth with the email correspondence.
So can you tell us what you've been doing for the last 2 years? Have you been working as a pharmacist?
So I work as an ambulatory care pharmacist and I am in Nevada, but I cover when we have an ambulatory care pharmacist that works in Phoenix. So when she's out on leave, I cover, but our daily skills are not under what you would call a pharmacist skill. So basically it's disease state management, and we provide information to the providers as far as guideline-based therapies and provide recommendations.
Were you physically present in Arizona providing these services?
No, the one service that I did do during the 2 years when my counterpart was out, I had a provider ask a formulary question about Entresto and the affordability of it, and if there was an option to prescribe something else that would still be in the guideline-based therapy. And that's what I performed. There wasn't any patient specifics that were discussed.
So when you practice or you cover Phoenix here, do you work under CPA or like agreement with physician here in Arizona?
No, we do not have a collaborative care agreement.
Okay, and do you modify medications? Do you
we provide recommendations?
Recommendations only? Okay.
Yes.
Do you work in a pharmacy?
No, I work in a provider's doctor's office.
It seems similar to this technician working under the physician. It's using your clinical knowledge as a pharmacist, but not using your license. Is that what we're saying?
Correct.
And the Board of Pharmacy, not Board of Pharmacy, but there was legislation run several years ago allowing the practice of pharmacy to take place in physicians' offices for cognitive services. So it's not limited to the four walls of the pharmacy.
But you still need to be a pharmacist to do
Yes.
that.
Yep.
So she
It's
would
still the
be
practice.
using
It's
her
still the
license.
practice of pharmacy.
Yeah.
Absolutely.
Yeah.
Madam Chair, Hannah may want to shed some light. I don't know if you have anything
Yeah,
additional.
please go ahead, Anna, if there's anything you want to add.
I don't think there's anything that I have. You have your communications from the license holder in your packet. She just didn't seem to want to be answering any questions, so I figured it'd be easier if she could just explain herself before the board.
So you work from Nevada and you hold a Nevada license, active
Correct.
license?
Correct.
At any point, did your Nevada license lapse?
No. And I'm licensed in New Mexico, Utah, and Florida, and at no point in time have those licenses ever lapsed.
So based on what she described, what she did, like just talking about formulary or counseling providers, what is it different if you have big company and pharmacists from different state just send those kind of recommendations and not licensed? I believe a lot of big company, they do that. They hire director of pharmacy who license in different state and send to the whole company like a recommendation. I mean, me personally, I don't see she have done anything different that. Now, if she interviewed a patient or did modify any medication and send the prescription and the provider name, if that will be a different case.
She only worked covering when a pharmacist was out. So how many approximate days would you say that would be?
So it was 7 days, and I interacted with one provider on one day.
We have standard terms for continuing to work without a license. We could do something with that.
Again, I don't see it this way because, I mean, if you are a physician here and your company has a pharmacist somewhere else, can this physician as a pharmacist or not? I mean, we're here to protect public. How we are, like, I don't see she did any harm or she violate any rules. I mean, I don't really see it.
It'd be like if you had a physician from another state call you that was your, friend, and they said, which of these is a less expensive therapy? You're not providing pharmacy services. Is that kind of where you're going with this?
Correct. And she's talking about formulary. It's not about or like question. I don't see her practice as a pharmacist in our state. She did not serve a patient directly. That's how I see it. She did not dispense medication, did not modify therapy. It's just when you have any pharmacist you contact to authorize medication, I always go to PBM. You don't know where's that pharmacist based on when you do peer-to-peer review. And peer-to-peer review, when we do it with PBM, it is really more like, it's like more against the law if that's the case, right? The pharmacist can be like in the state of anywhere in East Coast and the physician here in Arizona. Me personally, I don't see this is violate any rules unless we can prove that she did practice without a CPA, it's easier for me to pronounce this way, or if she modified any treatment or prescribed, then I will agree with you and then we need to act on this violation.
Miss Miller, Madam Chair, if I can ask. Were there any clinical judgments, practice of pharmacy that you performed, or is it strictly, is this medication cheaper, formulary related questions?
It was a formulary related question.
And just limited to that?
Limited to that. I didn't have any patient specifics, just what are the alternatives for Entresto for treating congestive heart failure?
I have like 2 motions got denied today. I'm gonna do my 3rd motion.
Go ahead.
So hopefully that will not get denied, okay, or declined. So I move to accept the application to renew her license in the state of Arizona.
Second. A motion and a discussion. Any a motion and a second, any discussion?
Do we think it's prudent to include a non-disciplinary letter of concern or advisory letter? Just, I mean, she acknowledged that she wanted to be licensed, that she forgot to renew her license. She believed she needed to be licensed. She probably has a job description that requires her to be licensed. So just include that advisory letter with it.
Just I have one comment before we move. Like, if she decide not to renew, we would not know about this issue, right? She would not be with us here questioning her, and she need to answer. Just she decide to renew her license, and we knew about it, right? Like, I don't think there is any violation to provide any advisory letter because she specifically said that she didn't discuss any specific patient. She didn't, you know what I mean, just was literally talking about treatment for Mary. I mean, I don't see it. I can ask online pharmacist. Who knows who that online pharmacist?
I agree with Mr. Aziz.
I have a question. Are there additional costs that are to be incurred from not having renewed and allowing it to lapse? Do we need to address that here right now, or is that?
She paid
did?
it.
Oh,
Yeah. I think seeing that she paid her fines, that a letter wouldn't be needed.
Any additional discussion? Do you want to do a roll call? I don't know if this is going to be.
Mr. Braswell.
Just for clarification, this is reinstatement, no advisory letter, correct?
Nothing.
Yep, strictly reinstatement.
This is,
Aye.
excuse me, I'm sorry, this is a renewal, not a reinstatement.
Renewal,
Gotcha.
we'll call it renewal / reinstatement going forward.
Aye.
Sorry. Mr. Thorwald.
Aye.
Ms. Nair.
Aye.
Ms. Davis.
Aye.
Ms. Walmsley.
Aye.
Ms. Lehan.
Aye.
Mr. Dang.
Aye.
Mr. Al-Nasif.
Aye.
Mr. Anderson.
Aye.
1 for 3 today, Mr. Nasif.
I guess I didn't need to do a roll call. Thank you for being present. Everybody doing okay? Or do we need a quick break? Let's take a 10-minute break. Okay,
Thank you, Madam Chair. Thank you, Board.
thank you. Right, everybody's back. Let's go to 30D, which is special request for Alyssa May Nono Ung. Is Miss Ung present?
Yeah, she's online.
Miss Ung, can you unmute yourself and introduce yourself for the board?
Yes. Hello, everyone. My name is Elisa May Ong. Thank you for having me today. I am here to request the board for another attempt at taking the Naplex.
So Miss Ong, you've taken the Naplex 4 times already, so this would be your 5th attempt.
Yes.
What are you doing differently to prepare it this time?
I'm using a new study platform called Pass Naplex Now. Previously, all I've used is the UWorld RX Prep platform, 2023 and 2024 versions. I have also tried getting tutors from Varsity Tutors. But what I'm doing this time, I don't know if you guys remember me from last meeting in December, but during that meeting previously, I requested for an extension for my intern license in hopes to get a job. But with it being my last time, most likely taking the Naplex, I've decided to just solely focus on studying for this exam. And so yeah, I'm using Pass Naplex now. I am in Nevada currently. I'm no longer in Arizona with my family to kind of get away from some distractions there. So my only priority currently is studying for this exam.
Thank you. Board members, any questions?
Not really.
I'll make a motion to approve the request.
Second.
A motion and a second. All those in favor?
Aye.
Congratulations, Miss Ong. Best of luck to you. Understand that this is the last opportunity that we'll have to approve this for you. So good luck to you and make sure you study hard.
Yes, thank you so much, Madam President and board members. I do, if I may ask a question, if that's okay.
I'd ask that you direct it to staff after the meeting. Thank you.
Thank you so much.
All right, let's move on to 30E. Miriam Damien.
Yes.
I am recused.
Hi, if you could please introduce yourself.
Hi, board members. I'm Mariam Demian, a foreign graduate pharmacist from Egypt, and I applied for pharmacist intern to the Board of Pharmacy of Arizona on December 8th of 2024. And I'm respectfully requesting a waiver for the TOEFL ABT testing as a requirement for the Board of Pharmacy licensure to get the FBGEC. And I actually was able to pass my FBGE test on 2020. And also I kept trying to get the required score of the TOEFL IBT test. And I was able to reach to the required score and higher on all testing sections, except only the speaking section, which the 26 is the requirement, but I was able to get that 25. And actually, I got it twice. And according to the ETS, a score of 25 is considered as an advanced level of English. So I'm just requesting waivers to obtain the internal license and move forward to get my pharmacy license. And since I moved to US, I've been pharmacy lead tech working as a pharmacy technician for 4 years. And I got promoted last year to be a pharmacy lead tech and also as an inventory specialist. So, and I am a certified immunizer as well.
Thank you, Ms. Damien.
Thank you.
I would just like give, because I know about this process, and so previously with the state of Arizona, talking about 2000, before 2009, that wasn't required to have the certificate. I'm foreigner pharmacists were able to be intern just by acceptance, getting acceptance for the FPGAE test. That's a long time ago. And I'm not sure when that changed. I believe that required now people to be certified to be an intern and a pharmacist. Is that right, Dr. Gandhi? So I know the score of her TOEFL score is pretty high. I believe is more than law school required for students. But me personally, I don't know if we allowed to approve her intern, but I'm not. But I thought the request for intern or for intern and to take NAPLEX. Are you asking us?
I submitted my application for the internal license to Arizona Board of Pharmacy, but they requested my ABGEC.
Correct.
I already passed ABGE in 2020,
Yeah.
but I'm not able to get the ABGEC because of my
Correct.
TOEFL.
But are you asking for intern license? And what? Let's say you finish your 1,500 hours. Are you gonna and you don't pass your TOEFL? Are you gonna ask for a pharmacist?
I'm requesting to get the intern license.
Only intern license solo. Yeah, I don't know if you have authority for that, but I'm open for discussion.
But she would still have to have the FPJEC to be able to take her NAPLEX, right? Because that's a criteria for
Yeah.
NAPLEX, and we
Yeah.
can't waive that. That's an NABP requirement, correct?
To take the NAPLEX, she'll need both, the TOEFL as well as the FPGEC.
To take, yeah.
There's no waiver process for a pharmacist. For an intern, there is a waiver process, but not to be a pharmacist.
Miss Damien, do you understand that?
Yes, I understand that, but so if I get the intern license when I'm trying to apply for the NAPLEX, do you mean that I'm not going to be able to apply for that test because I didn't pass TOEFL test?
What we said, we might be able. I'm not. We're gonna discuss that further. Give you an intern license. I'm not sure if people agree here, but to take the NAPLEX, you still need your certificate, the FPGEC. That's we don't have. My understanding, we don't have authority to waive this requirement. Since intern only our state, we might have this authority. We could discuss it further, but that's my understanding.
You have that authority under Arizona Administrative Code R423-303. You can waive an intern requirement, but you can't waive that requirement for a pharmacist applicant.
Okay.
So Ms. Damien, your address here shows San Diego. Why are you applying for Arizona, and have you applied for California?
Yes, because when I contacted California Board of Pharmacy, they said that there is no waiver request. And yeah.
So some states, they give waiver, other states don't give. So it depends. That's why like foreigner pharmacists, they kind of like, I don't want to say shop, this is not like a nice word to say, but yeah, they just contact different states to see who will give them this opportunity. To me, like intern, I'm okay with that. You know what I mean? Under supervision and
I agree. I just want her to understand that she's not going to be able to become a pharmacist and that she might get this intern license and it perhaps isn't going to lead any further. I mean, I hope that she continues to work towards that. And if she's able to take it and pass, it's great. But we can't grant her a pharmacist license without the certificate.
So we had a very similar case to this several meetings ago, because I remember this discussion.
Yeah.
And I can't recall what the
issue was there.
It was the same thing. It was
No,
wasn't
it is same request, but the issue there was did not pass the FPGAE, did not even submit application to an APP. So we had issue. We didn't know if his degree was validated by an APP.
Got it.
So he said, you know what? I'm a foreigner pharmacist. I want intern license here. Right? But here, she showed she took the TOEFL many times. She had high score. She passed the equivalency exam. And she's only need like one step. She's like one step to be certified.
Yeah, I feel that I'm just 1 point away from achieving my goal to be a certified pharmacist.
If I may, Madam President, what might be concerning to Ms. Demian is the knowledge that her FPGEE is going to expire later this year. So if she gets an intern license under this waiver, and then she later wants to become a pharmacist, like at the end of 2025 or in 2026, she will have to start the FPGEC application process all over again, and she'll have to retake that FPGEE. So that exam, it only lasts for 5 years.
So when did you pass your FPG? 2020.
2020, October 2020.
Okay. So, and just like, I don't know if this is gonna affect any decision here, but I know NAPP is reviewing the TOEFL request score. I'm sorry, because it's really, I mean, it's very high requirements. So things might change in the future. I'm not giving her hope because she have limited time, but as long as she understands, we only allow her for intern if board member.
I guess my question, Ms. Damian, is what advantage is having an Arizona intern license going to bring you?
Just because me and my family were thinking to move to Arizona. That's why I started to contact Arizona Board of Pharmacy if they can waive the TOEFL requirement from me and to be able to get the intern license and move forward.
But the ultimate goal is to become a registered pharmacist, and you have until the end of the year to do that with the certification that you have on
Yeah.
file.
That's what I'm keep trying to do right now. And 2 weeks ago, I was able to achieve more than the score I just sent to you. I'm gonna show it to you.
So we allowed to waive intern requirement, not pharmacist, right?
You can waive the FPGEC certification
intern.
requirement for intern.
Intern, okay.
You can't waive the TOEFL.
For pharmacist, yeah.
Correct, yep.
For pharmacist, okay.
I'm all for waiving it.
And yeah, I move to approve request.
Second.
I have a motion and a second. Any further discussion? All those in favor?
Aye.
Any opposed? Hearing none. Thank you, Ms. Damian. Best of luck to you.
Thank you so much.
All right. That takes us to 30F, and I am recused.
All right, this is tab number 30F, special request. Staff member is Ms. Mitchell and subject is Thai Song, case number 24-0670. Is the
T-Song is online, Mr. Chair.
Hi, Ms. Song, could you please introduce yourself for the board?
Hi, my name is T-Song.
Thank you, Ms. Song. Ms. Mitchell, could you provide us a brief summary?
Yes, I'll try to be very brief. On or about November 15th, 2024, staff audited Ms. Song's compliance with the continuing education requirements for the 2021-2023 renewal period. The audit revealed that Ms. Song was short 16 and a half hours of continuing education. On December 6, 2024, staff opened a complaint against Ms. Song's license for failure to complete the continuing education required for renewal. On December 11th, 2024, staff offered Ms. Song a consent agreement for civil penalty, continuing education, and audit to resolve the case. Ms. Song responded to the proposed consent agreement and indicated that she accepted the penalty, but asked if the amount of the penalty could be reduced, which is why she's here before you today.
Thank you, Ms. Mitchell. Ms. Song, did you want to make a statement before we open the floor for questions?
Sure. So thank you for allowing me to be here today. I just wanted to say that during that time period, I have a major surgery in the family, and we're still on a payment plan with Mayo Clinic. So financially, it's been really tough for us. So that's why I'm here today to ask for some leniency on the momentary fine.
Thank you. Board members, do you have any questions?
I don't think we can. No.
I think what we've done in the past is maybe given an extension in the time frame able to pay, but we've not been
Yeah,
able
we
to
never-
change
we
the
never
cost of
changed,
that.
no.
Is that consistent?
No, we cannot.
I would certainly be for giving an extension.
How long? How long of an extension did you have in mind?
What's the current deadline on the consent agreement?
How much time?
The current deadline is 90 days
Okay.
from the effective date of the consent agreement. So that would be when she signed it.
Oh, she hasn't signed it yet. So she already has 3 months.
So Ms. Song, you have 90 days built in from the date that you sign. Is that sufficient time?
Yeah, I think that's fine. I'll work with whoever to see if I can make payment plans or anything like that.
We don't have payment plans. We're just not set up to be able to handle that, but you do have 90 days from the day that you sign to make the final payment.
What if we gave your 90 days? Would that allow you to ensure that you're paying it? Because after that, you wouldn't have any more time.
Would 120 day be allowed?
So currently you have 90 days. We can, what we're discussing, add more 90 days. That will be 180 days from the, right? That we submit.
She just asked for 30 more days.
For
She
30
went
more
from
days, yeah.
120.
If we are,
She's already got a couple more months, so she'd already have that with another 90 days on top of it.
I would say if we do decide to go this route, that we say if not signed, not paid, then proceed to hearing.
I would agree with that.
Okay, I'll make that my motion. 120 days after signed, if not signed, or if not paid, proceed to hearing.
I second.
If not signed within 30 days?
If not signed within 30 days and if not paid within 120 days, proceed to hearing.
Modify my second.
All right, so we've got a first and a second for a modification. Any further discussion? All in favor, please say aye.
Aye.
Any opposed? Motion carries. Thank you, Ms. Song.
Thank you.
And we'll welcome Ms. Walmsley back for tab 30G.
All right, Garrett. Welcome.
Madam Chair, just a little intro, if I may.
Absolutely.
I think last time we had an opportunity to hear from Mr. Garrett Turner, the new CEO of AZPA, and it was a one-sided interaction. He introduced himself. Because it wasn't on the agenda, we weren't able to entertain dialogue with him, so that's why he's on the agenda.
Welcome, Garrett.
Awesome.
Nice to see you in person.
You as well.
Where is yours?
Well, so thank you again for having me. And once again, I'm standing between you and lunch, so I'll keep it as brief as possible. But as of next week, I will have been on the job for 90 days. And I've done a lot in that time. And what I mean by a lot is I've visited quite a few different compounding pharmacies. We've gone to plenty of independent pharmacy coalition dinners. I've had the opportunity to spend some time with Dr. Gandhi and some of the other board members that are serving as members of AZPA, learned more about what you're doing in your respective areas, and again, about the important work that's done here every single month. What I want to share with you is we've also conducted a 2025 Pharmacy in Arizona Outlook survey. We had an incredible, turnout in terms of results and response rate. I'm still in the process of compiling all of the different information that we were able to gather, but we did have students, technicians, pharmacists, and the like participate, both member, non-member, and individuals who reside here and practice here, and individuals who reside elsewhere but still practice here at various times. As we've seen today, there are a variety of practitioners that interact with this state. So I look forward to sharing those details with you as soon as final tabulations have been compiled. But a lot of what we have been able to determine is that we've got some key focus areas. This past weekend, in fact, we just held the first ever board retreat of its type, I should say, where we really sat and focused on the future, not only of the association, but of the profession, and have come up with kind of 4 key areas that we've got to focus on. The number 1 area is an elevation of our educational offerings. I think that there's plenty of evidence, is what I'll say, to the need for that, not only by way of the laws and the requirements for anyone that holds a license in the state of Arizona, but also a little bit of education for the public as well. Part of that actually relates to number 2, which is workforce issues. So we have, been able to find data in various places, and I'll work on citing all of that for you when I provide you with additional details. But turnover rate for technicians in the majority of the workplaces is over 25%. It is unsustainable for these organizations to continue to do the work that they need to do every day when turnover at the kind of lowest level is just a churn and burn. And so we want to figure out what we as an association can do to help with that. I think that there are also plenty of ways that the Pharmacy Association can play a role in working with the pharmacies themselves, the PICs, and the technicians on the various issues that they are all experiencing with relation to the number of hours, the amount of prescriptions, and the general public that they are experiencing. So workplace conditions and workplace issues, go hand in hand, but we'll be focusing on them in a couple of different ways. And finally, the last thing that has come up, not only for us as part of the survey, but something that we have heard from legislators about in the state, as you can imagine, is a lot of what goes on in rural Arizona. There are true healthcare deserts out there, and no pun intended, because we are in Arizona, but where this is also related to the workforce issues, but where can pharmacists continue to help fill those spaces? There's not only a shortage of pharmacists and technicians, but also of primary care physicians. And as a result, some of these rural areas where there might not be a healthcare professional for 100 directions in either, or 100 miles in either direction, could be assisted by pharmacists. And so we are looking at not only how we train for that, because there are also issues that are going to be slightly different in rural areas than they are in urban areas, but also what we as an association can do to leverage our network and to better promote, filling those gaps. So again, I'll just kind of say high level, those are the 4 main areas that we are focused on. We are bringing in some new staff members, which will additionally allow us to have the extra hands we need to deliver on the promises that I talk to you about each time I have the opportunity to do so. But lastly, I'll just say I am very much committed not only to what we need to do for the professionals that are pharmacists, technicians, and the students who are working to obtain their licensure. But I'm also committed to what you all need to do to protect the public. And I think that starts with that education of those professionals who are out there. And so I ask you to also think about how you can leverage our organization in partnership to do better about that. So with that, I'll turn it over to you if you have any questions.
Thank you, Garrett. Board members, any questions for Mr. Turner?
Don't make them too hard either.
No, it's not a question.
When will you release the results of the survey?
Yeah, so that just closed on the 31st. We anticipate releasing those results probably towards the end of the first week of March.
Is there any new concepts or creative ideas that are being used to help rural areas?
So at this moment, no, something that part of the reason I brought it up while we were at the regulatory affairs and government efficiency meeting the other day, promoting Bill 1214, which is the test and treat bill. You know, the senator who represents Yuma brought up some of the issues he's facing around getting healthcare professionals, period, but especially pharmacists in that area. So we have had kind of a side conversation about what we can start to do to brainstorm, you know, rectifying that particular type of situation there and in other areas around the state. But nothing as of yet. We've just been very aware of it, but nobody has really convened the thought leaders the way that they need to be convened in order to move that forward.
So no blimp pharmacies or drones?
Not yet, but maybe it's on the table.
Drones are allowed in some other states, so I don't know.
I've got a question.
Yes.
You mentioned education as a top priority. So we've recently been doing education here and the board issues education certificates. Is there an opportunity for a potential partnership where AZPA actually does the work to issue ACPE accredited CE for our board meetings? I don't know if that's been explored, but I know AZPA does do that. I don't know if that's permissible or.
That would be great, actually. Yeah.
I think we looked at that with Kelly before, didn't we?
We did during our district meeting.
Yeah.
And we can take that off, but I think at that time, there was concerns about having that relationship with AZPA because our mission and their mission is slightly, it's not aligned, right? So they have their mission, we have ours to protect the public. But we can definitely have that discussion again. I think times are a little different.
Yeah, I think you know, one of the things to your point, one of the things that we plan to do is hold a pharmacist in charge session at our annual convention and so forth. But why I think it would be so worthwhile to have ACPE accredited, you know, CE offered as part of attending these meetings is because there's a lot that pharmacists could learn about the mistakes of others. And so for me, while the missions are different, the one thing that is the same is that we want the best for the patient at the end of the day. So I think that there is a conversation to be had, and to your point, we can have it at a later time, but there is true benefit in hearing the stories, both, you know, the internal stories about mistakes that were made and the external stories about how patients could have been or have been harmed to prevent that from happening for others. And I'd be happy to take that up with you all at a later time.
I know spring clinical is Saturday. Just wanted to bring it up because it's a unique opportunity for people to come to a conference, maybe if they haven't been before.
Yeah, much appreciated. And one other thing that I'll mention is our annual convention will be wildly different than before. And the reason that I bring that up is going back to the education and workforce issues piece. We are going to hold some pre-conference sessions for not only pharmacists in charge, but we're thinking about getting together leaders like yourself who are, you know, kind of above the pharmacists and really working in the business of pharmacy so that we can also do some brain sharing there and some education there to make sure that, again, all of the things that we're talking about as, you know, possible issues in the profession are starting from top down and being shared appropriately.
And I think we had talked about that a couple of years ago at the NABP district meeting, kind of getting together a collaborative, if you will, with the boards, the association,
The schools.
Yep.
Right.
And we've never really gotten any traction on that, but I think that there would be some benefit in kind of talking through at a high level what the challenges are.
No, absolutely, absolutely. And I just want to add that I think as of recent, we've had some good interaction. There's more transparency and more open dialogue as of recent, which is refreshing. I think the barriers are kind of being removed. The guards are being let down. So it's a positive move forward.
And I think in collaboration, I think we can improve pharmacy for the citizens of Arizona. I mean, ultimately, that's what we all wanted.
Right.
And you mentioned the PIC course. I think it would be great to have some of board members, compliance officers on that faculty. That would be amazing.
All right.
Anything else?
Thanks, Garrett.
Awesome. Well, thank you all
Appreciate it.
for having me here, and thank you for your time. I look forward to, again, being able to share more with you in the future.
Thank you. Dr. Gandhi, I know you have to take off. Is there anything you want to address before you leave?
There are two matters that I'd like to bring back up that's in my agenda item, which is, of course, a calendar for April and June discussion. I think we had a discussion earlier, Madam Chair, that you may be able to participate virtually for your April meeting. So having researched this a little bit and having internal discussions, I think it's best that we keep the date the same.
Thank you for looking at it. And I guess good note for the future, if we need to look at moving, we need to decide before a meeting before because of timing.
Absolutely.
Good for all of us to think about. So if there are conflicts for the future, let's bring it up sooner. That's
Yeah.
bad on me. So I will make my best attempt.
And then for the June meeting, I think Mr. Anderson's not available, but moving that meeting may not be good for somebody. So I think it's best that we keep it the same. The second thing I'd like to address is I did receive an email about our non-disciplinary complaints and how we manage it. And there was concerns about why are you even wasting time and resources addressing those complaints. And unfortunately, a complaint is a complaint, and statutorily and the way we operate, that we have to exercise our due diligence the way it's set up today. We are continuing to think about it, may require statutory or rule change to bypass wasting resources. And it makes sense to do it, but it obviously with the pace of government, it takes time. So I did want to address that because I think there's a misunderstanding on why you even doing this, right? Because we have to. And because we have to, unfortunately, it comes with the cost of wasting time.
Well, and I'm also sensitive to what it means to the people that are undergoing the process as well, too. It's not fun for our license holders to be waiting for a response from us.
It's not something we want to do either. Obviously, we can use our resources elsewhere and be more effective, but until the laws change on how we can better manage these things, we have to exercise our due diligence with every complaint that comes in. So I just wanted to explain that to the general public, because I think there may be some misunderstandings.
Thank you.
I think with that, Madam Chair, I think that closes out my report from yesterday.
Okay, thank you. Ms. Canavong, I think you said that there was somebody present from a prior agenda item. Just want to make sure that we take care of that.
Sure. Yep, that's Miss Keandra Whiting. She's in the Zoom room.
Miss Whiting, if you're present.
Hello.
Ms. Whiting, we've already conducted your hearing earlier today. Did you have something that you wanted to address with the board?
The only thing I have left to say is that I did finally reach the district leader or the district manager at CVS. Because right now I left them in October, so it's like I had to figure out like look for the district person, and I had spoke to HR and they said they're mailing me my transcript of all the modules, and it comes after this court date. So I was like, can I still like send it to you guys to show that I did take action? I wrote the letter and I also did the courses.
Miss Galvin, Mr. Hargraves.
This is a little bit dicey because we can't really advise you. This was a hearing matter that requires independent advisor. However, the matter will be sent to a written final order, which will lay out appeal rights. So if she's got something she wants to add, she can include that as a possible request for rehearing or review.
Miss Whiting, did you understand what Mr. Hargraves is saying?
No, this is my first time ever being in court, so I think yeah, I don't know.
So we voted earlier today to revoke your license.
Okay.
And you will receive a written order from the board stating that, but that order will include rights for your appeal. It sounds like there is some additional information that you potentially could have provided to us earlier today, but you weren't present. But there will be information on how you can appeal that case and to provide additional information.
Okay.
So you'll get something in the mail. And if you've got questions, once you get that in the mail, I would suggest that you reach out to board staff and they can advise you potentially on what those next steps might look like. Okay?
Okay. So it's just revoking my license, the Arizona license or training license, because that's what it is, just a training license.
Yes, it's revoking your Arizona technician license.
Okay.
And like I said, you do have appeal rights and those will be outlined in the order.
Okay. Thank you.
You're welcome. Thank you for being present.
No problem.
I also had a request, Mr. Anderson, keep me honest, item 25.
25B, tab 25.
25B, there was some confusion around who we were going to refer to.
Yeah, so we had a discussion on complaint 24-0419 yesterday, and we talked a lot about the pharmacist and the pharmacist's responsibility, but I was wondering if this is primarily for the Assistant Attorney General, should we be referring this consumer who fraudulently obtained the furosemide to the appropriate agency, whether that's Maricopa County Attorney, or who do we refer that to if that's not automatically done?
A referral is typically not automatically done. It is within the board's discretion to make that referral. And if you're interested in doing that, a motion would include a referral to the Attorney General's office and any other law enforcement office that is deemed appropriate after research.
I would like to make that my motion.
I'll second.
Any discussion? All those in favor?
Aye.
Any opposed? Hearing none, motion carries. I think that takes us to item 32, discussion of items to be placed on a future meeting agenda. Anything anybody wants to add to a future meeting?
Yeah, I have quite a few I like to discuss in the future.
Who's taking notes?
Yeah. So yeah, please take notes. So yeah, tell him I was okay. So I have
cut
noticed.
you off on the Celsius.
Hopefully, you guys will like my agenda items, but we have noticed quite a few errors with the technician administering vaccines the last couple of meetings. I have observed the waiting time in the pharmacy, like long time everywhere. Pharmacists are burned out. Technicians are burned out. I would like to discuss pharmacist to technician ratio, if we can talk about this. I know I saw people shaking but I believe it's important. I mean, at least to discuss it as our job to protect public. So when we see pharmacists having 6, 7 people around them, that increase error. And it's proven we look at those error and mistake reported to the State Board of Pharmacy. The waiting hours, 3, 4 hours. Transfer prescription, 2, 3 days. If it's serving the public. I don't know, maybe. So
How does having a technician, what we can save it for another discussion.
yeah, but
I don't
just-
understand where you're going.
Yeah, we like to add this, just at least to discuss it, right? So the other thing is allowing technician to accept declination. That will relieve a lot from a pharmacist also.
Is that already allowed? Is what what I would ask.
That we discussed that within, I believe before, but not allowed, right? We discussed it just to add to the agenda, like allowing technician to accept declination. And also.
It's a non-clinical function.
That's what I thought, but obviously the rules, my understanding that.
Yeah, we just can't discuss it right now. We'll put it on a future.
And the third item is we can talk about NABP requirement for, just because of the case, we just, for certificate requirement, just discuss it as well. If we need to waive for pharmacists. That is statutes, yeah, but we can just discuss it.
Anything else?
I have one. Statute changes, if there's any needed, or for instance, with Ironwood today, how those are statute changes needed for some of these kinds of issues that come before us to clarify things, to make things simpler and easier, and so that things don't fall through the cracks. If so, I'm just a discussion about that.
I may feed off of allowing the tech declination to maybe seeing about a technician offer to council potentially to help with facilitating, the pharmacist to be available, but to also be able to do the multiple tasks.
So the counseling rules just in general.
This is maybe not appropriate, but I think that I want to hear follow up on the things that we've already asked to be on the agendas, like changing fees, if it's going to be disciplinary or non-disciplinary. I can think of several things, and I still don't know like what's happened with them.
Okay. Okay. Anything else?
So can my item be discussed next meeting?
We'll have to see what the agenda looks like. Probably not the next meeting. Probably not the next meeting, Tariq. We will have new board members.
Rulemaking committee meeting?
Yeah, maybe.
Coming?
I'll talk to Dr. Gandhi about it offline. All right. Any other future agenda items? All right, that takes us to 33, election of officers.
I move to keep it the same. Ms.
Could you
Walmsley
please be
and-
more specific?
Can you be
I will-
specific?
Chair, yeah, I will pass my motion to move for maintain our Madam Chair here, Lori, and Dr. Anderson as Vice Chair. That's my motion.
I'll second.
I have a motion and a second. Is there any other? Huh? Discipline? I was going to say, is there any discussion or other alternatives that anybody wants to throw out there for the group?
The Complaint Committee Review Committee.
That'll be the next one. Mr. Anderson, are you willing to serve?
Yes, I am. Thank you.
I
Thank you for the
am
nomination.
willing to serve as well, and thank you for the nomination and the confidence. All right, all those in favor?
Aye.
Any opposed? Hearing none. The Complaint Review Committee, I don't think this is actually like an official election. We've typically had the chair serve and the vice chair serve if the chair is not available or any of those types of things. I know we have some board members that are for sure rolling off that have typically participated. Does anyone want to volunteer for the Complaint Committee?
I would like to volunteer to have that opportunity.
You're already on it.
Move to keep myself. Just
You would like to continue to serve on the Complaint Committee?
And I'd like to continue as well.
And Ms. Lehan, you would like to serve on the Complaint Committee?
I think we can have backup.
Yeah.
Folks, that we can rely on in an event you're not available
Yeah.
for, Mr. Anderson. Absolutely.
And I think we've done that, which I think has worked well. So I would hope that we could call on any of the board members in the event that there needed to be an absence so that we can keep the business of the committee moving because it helps with the meetings. But do we need an official motion?
How many people do we generally want? 3 to 4?
4.
Because right now I think you have 3. If you are there, Jeff is your backup. You'd replace me. Kevin was there.
1, 2, 3, 4.
So 1, 2.
We can only have a
Oh, we have
maximum.
4.
We can only,
I didn't think both of you would be there.
No, Cedar, Frank,
Oh,
Bree,
okay.
and either me or Jeff.
Got it. Good.
so, yeah, maximum is 4 allowable.
Okay.
Do we need a motion for that?
As chair, you can appoint the members.
Let's just take a motion. Is everyone do I have a motion to accept the nominations? Second. All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Have we covered everything except for call to the public? Everything's good? All right, call to the public.
While you're waiting for that, Madam Chair, I do have to go to another meeting. So thank you. It was a great meeting. Good job running it. And we'll talk soon.
Thank you. Yes, we'll definitely do some sort of an acknowledgement.
You want to say something? Jen.
While we're waiting, if the board members could leave their folders on the table so we can collect those back, we'd appreciate it. Thank you. Okay. Actually, all of it. Yeah, thank you. I don't think we have anyone. Thank you.
All right, we will adjourn the meeting. Thank you.